On the original side, seeking Lordship's leave to mention one matter, Lordship. This bank guarantee matter on 23rd August, Lordship had been pleased to pass this order. Lordship, I just want one word to be added, that registrar will be paying the money, not the entirety, but after deduction of the commission. Okay. So the commission is being deducted and the bank guarantee I have already prepared with that amount. So instead of 90 lakhs, which was to be paid, what is being paid is about 89 lakhs. So I just want leave to file that bank guarantee, Lordship, with that one addition of that word in that.
But who will be the other side?
I have given notice, Lordship.
Well, I appeal for this one.
Lordship. He's for the appellant, Lordship. I am for the respondent.
So you will furnish the bank guarantee less the commission.
That's all. I have already prepared. Everything is ready. The learned registrar asked me to come and obtain leave. Everything is ready. The amount of the bank guarantee is 89 lakhs 53,530.
So we will not mention the amount. We will say by order dated 23rd August 2023, the respondent writ petitioner was permitted to withdraw the amount which is lying in deposit with the registrar, original side, pursuant to the directions issued by the learned single bench by its order dated 17/5/2023 in WPO 2166 of 2023, along with accrued interest, subject to the condition that the respondent writ petitioner furnishes a bank guarantee for the entire amount which is now lying in deposit, that is inclusive of accrued interest. It is submitted by the learned counsel. You are appearing for the respondent.
I am appearing
for the respondent writ petitioner that the bank guarantee amount may be directed to be furnished for the sum to be mentioned by the registrar original side after deducting the commission payable. Full stop. Accordingly, the registrar original side is directed to accept the bank guarantee for the sum after deducting the commission payable, and leave is granted to the respondent to file the bank guarantee for the set
and pay the amount accordingly.
Consequently, the amount lying in deposit less the commission shall be withdrawn and paid to the respondent writ petitioner. This order shall form part of the order dated 23/8/2023. Mentioned first line, the matter has been listed under the caption to be mentioned.
The bank guarantee should be renewed as directed by your lordship.
Yes, 1 year.
That is already there.
It is already the form is
the other directions issued in the order dated 23/8/2023 shall continue to operate.
Obliged, Lordship.
I can leave my lord in the appellate side, my lord.
To file without all right, leave granted.
My lord, may I be permitted to mention one matter, my lord, for correction? Instead, appellate side matter, instead of Paschim Medinipur, it will be Purva Medinipur. My lord, district magistrate Purva Medinipur, my lord.
The matter has been listed under the caption to be mentioned. It is submitted by the learned advocate for the petitioner that in the order dated 9/10/2023, in paragraph 1, the name of the district has been mentioned as Paschim Medinipur, whereas it should be Purva Medinipur. This correction be effected in the order dated 9/10/2023, and this order shall form part of the said order.
My lord, under compelling circumstances, I am mentioning one matter regarding item number 67 of today's appellate side matter. My lord, this teachers organization before your lordship to seeking a permission for a rally and sitting.
Yes, you said that.
Yes, my lord, it is 67.
It won't reach today because
Mr. Amitesh Banerjee is appearing for the state, and I am led by Mr. Pratik Dhar. So Mr. Dhar is seeking only 5 to 10 minutes to conclude the. So if your lordship kindly enough to permit today or tomorrow at any time apart subject.
Item 66.
67. Day after tomorrow is the proposed program.
Tomorrow it can come. Tomorrow.
My lord, may I kindly to mention, my lord, may I renew my prayer, my lord? What happened, my lord?
I'm the banker. My lord, my security has been directed to be
Date
returned.
is running in the list.
61, my lord. The urgency is, my lord, the security has been directed to be returned. That is the difficulty.
All right. Tomorrow you upgrade the matter.
61, my lord.
61.
Deeply up. I'm mentioning up note.
May I have minutes?
Deeply.
Number 56 of today's list, my lord.
Hmm.
At this matter, my lord, what happened? I succeeded in the repetition. My retail outlet dealership has been terminated. Termination has been quashed, and I filed a contempt. Now I could not able to proceed with the contempt under single is not
Because
because
appeal is
pendency of the appeal. A termination order has been.
Any interim order is there in this appeal?
No, my lord, there is no interim order.
Then why do you worry?
Landed single, your lordship knows that since the appeal is pending. But order of the landed single is of the July.
And who appears for Indian Oil
Mr.
Corporation?
Pushpendu Chakraborty for the appellant.
Let us see how we progress today.
Yes, my lord.
If possible, we can upgrade. I will make a note. We can't assure you.
Lord, may I have my lord's kind leave to mention item
Then may
number
I hand over-
33
Hmm.
of my lord's list. Lord, this is a matter which, my lord, we had started arguing whether IBC, my lord, overrides that, my lord, coal scam matter where the liquidator wanted to proceed. I know before the vacations it's not possible. The only urgency is, my lord, now the IBBI has, my lord, started making inquiries about the liquidator because there are, my lord, certain observations about the liquidator's bona fides which, my lord, don't appear from the record. It's nobody's case that the liquidator, my lord, was, my lord, malafide already or had any connections. Yet, my lord, the judgment, my lord, records that. I am only praying for, my lord, stay of those portions. Otherwise, my lord, the liquidator was a chartered accountant. His whole, my lord, career, my lord, is at a, my lord, loss.
All right, we'll upgrade it tomorrow only
My
for
lord,
this.
only for that purpose, my
And
lord.
you please mention to the
I have given notice. I'll inform them and give them another notice.
and you tell them that this is the point you're
Limited
You're
point.
going to
I'm
cancel.
grateful.
You
I
upgrade
will
it tomorrow.
May I, my lord,
Completely.
have your lordship's my lord,
Great.
kind leave to my lord, file my lord, without certified
Without
copy, my lord,
Urgency.
my lord, the agencies, my lord, your lordship, my lord,
Next week it will come.
any day, my lord, any day, my lord, the only,
file it
I
next
shall
week.
supply the number after filing, my lord,
Yes.
at the top, my lord, so that, my lord, because on
Feel good.
18th, my lord, is the compliance date fixed for return of the money.
All right.
My lord, kind leave for mentioning for the inclusion in the list. My lord, the urgency is due to enormous order passed by the honorable single bench. My lord, the principal secretary is at threatening of contempt application.
You give the letter.
My lord, may I have
My
my
lord.
lord's
My lord, may I have my lord's leave to mention item number 73 of your lordship's list, my lord, original side. My lord, the only urgency arising is, my lord, I have in an auction been able to be successful bidder. Now, my lord, I am trying to, my lord, pick up the goods that have been sold to me. My lord, in the meantime, my lord, because the my lord, the authority, the NJMC, from whom I have, my lord, been able to be the successful bidder, my lord, had, my lord, stopped me from, my lord, taking away the sheds. My lord, that is under appeal before your lordship, my lord, because we've come up from the single bench. The only difficulty is, my lord, now, my lord, my men and labor at the site, my lord, goons are coming in, materials are being stolen, my lord, even gunshots are being done. One of my labor has been shot down. So, my lord, the only urgency, if your lordship can kindly take this, my lord. Great.
My lord, may I have my lord's leave for this matter. My lord, this is for assignment. My lord, this two contempt petition, my lord, was pending before my lord Justice Talukdar and my lord Justice Banerjee's division bench, my lord. After my lord Justice Talukdar's retirement, my lord, the bench, no bench has been constituted. I have already wrote a letter to my lord's office, my lord, through the
I
register.
think I've already signed that order. You just verify from the secretary,
My lord,
or I'll do it today.
my lord, grateful lordship, grateful.
My lord,
May I hand
my
over
lord,
the sleeve, my lord?
No,
for-
you hand it over to the OSD.
My lord, I will. Great,
Samrat Gupta.
grateful.
My lord,
My
may I
lord.
have lordship's kind leave to mention one review application passed by your lordship and the honorable justice Ajay Kumar Gupta, my lord. If your lordship any time, my lord. Grateful.
My lord, may I be permitted to mention one matter on the appellate side? This is an appeal arising out of a judgment dated 25th January. It's running in the combined list as item 946, praying for upgradation, my lord.
What
If
is the urgency?
the urgency is that electricity towers have been constructed at the entrance of the appellant's plot of land, which is denying ingress and egress, harming her business, which operates out of that land.
Immediately after vacation.
Much obliged.
Yes. You give a date immediately after vacation.
Notice has been given to the other side. ma'am.
Yes, sir.
So we had mentioned that matter of the 11th August against State Bank. You had given a date of 29th September. It didn't come in the list. So last Wednesday I mentioned it. You said to give a letter. I gave it for request on Friday. It didn't come. So I'm mentioning today request kindly do a hearing on tomorrow, Friday.
Hey, Sudip, note down this.
Please, sir, I'll be very grateful.
May I
sir.
have your
Just
lordship-
matter 10, 15 minutes. Sir.
May I have
Thank
your
you.
lordship's kind leave to mention item number 2 from in a lordship's list today, my lord, sir, appellate side list. And I'm told, my lord, appellate matter, my lord. Well, my lord, in this matter, my lord, if this matter is not taken up either today or tomorrow, my lord, then rule has been issued against me, though I am not entitled to pay the amount of 3 crores and odd. It is entirely upon the municipality.
Let us see.
No, my lord, it is totally entirely dependent upon the state government project and state government
That
has
your lordship will kindly.
trusted municipality to execute the work.
You please
Not
wait, please.
My lord.
Because only one appellate side matter will be taken up today, I'm told, my lord.
Let us see, we'll see. We'll
My lord,
take, wait, please wait, we'll take up 2 also.
My lord, may I be permitted to mention item number 63, my lord, matter relating to my lord permission for performing puja, my lord. My lord, extreme urgent, my lord, take this matter
All
before
right, item 63,
63, my lord.
you upgrade it tomorrow.
Grateful.
My lord, may I be permitted to mention 2 original side matters appearing at item number 53 and 54 of your lordship's monthly list. My lord, the honorable single judge disposed of the writ petition in the absence of the appellant by directing the appellant to disburse an amount of rupees around more than 65 lakhs within a period of 4 weeks from the date of the communication of this order. Now, the matter was mentioned before your lordship after filing the appeal. Your lordship allowed that mentioning. Now, even in the daily supplementary list of 6th of October, the matter was appearing as item number 6 and 7. Now, my lord,
Now it's gone
in
back.
the monthly list, the matter has
You
gone
give,
down.
you give it. Anjan is very fair. Yes.
My lord, may I permit me mention, my lord, I want to draw your kind attention. My lord, during the Durga Puja, online portals was open. My lord, online portals all data uploaded. On the basis of the data, permission was given. My lord, that's the problem. My lord, fire brigade at least my lord given the spot verification. Otherwise, fire brigade giving the permission, he cannot rescue there. There is a narrow passage. My lord, one by after my lord permission was given.
You are challenging that.
Yes, my lord. This is my lord. My
You give the list. Yes. You want upgradation.
Writ petition was dismissed on the ground, your lordship, that no undue favoritism could be shown, your lordship. But we have specific case that the undue favoritism has been caused in favor of the allottees who have been allotted the tender, your lordship.
There is MAT 1551.
Yes, your lordship.
We'll see. You please give, let us see the file and take a decision. Yes, please call the list.
Appellate side, daily list, serial number 1.
What happens, sir?
The lordship have kept it for compliance. Order passed on the 4th of October.
What happens?
May I indicate? Let me, because both of us, kindly see, my lord's order, my lord. There are 3 things I want to submit. First is, my lord, that so far as the Lucknow is concerned, because last evening, very late night, supplementary affidavit has been forwarded to us. I don't know whether they are relying upon or not.
You're relying on anything.
Very well. Then, my lord, kindly come to the order part. My lord, kindly see 2 things. One is, today the situation is, they themselves say that they will rectify and give 2 evaluators. Now, my lord has indicated that this requires an inspection by the Lucknow team so that it is compliant, because my lord, today they are saying about their insolvency, we are saying about the safety and security. Now, my lord, there are more than 100 reports which is there before my lord, which says this product as of today, what they are supplying is causing, my lord, defects and leading to accidents.
All right. No, you are not ready to comply with the order.
No, we are. We have already started. They have.
No, then please file a.
No, my lord, we have already, they have given us some documents. We are scrutinizing that.
There are only 2 ways of it. Either you comply or take it on appeal.
My lord, may I indicate
this sort of argument?
No, my lord, we are my lord, they are saying we are not complying. With all humility,
please comply and report.
Yes, but we have started compliance. My lord, this cannot be done, my lord, with all humility. This is my submission. This is not to irritate, my lord.
Sir, you can always file an appeal.
The paragraph 12 of your lordship's order.
May I indicate, my lord, this paragraph.
In the meantime, even pending, my lord, this exercise, they must, my lord, accept supplies. That is paragraph 12
No,
of your
my lord,
lordship's
this
order.
is something which I want to indicate, my lord. Let my lord take a decision, my lord. So far as this paragraph 12 is concerned, absolutely clear, my lord. This is on the basis.
We are not here to modify this order.
No, my lord is not
we will
required.
say today, the order and direction dated 4/10/2023 is affirmed, is confirmed, and we grant you time to comply with. Otherwise, we issue suo motu action of contempt.
My lord, that is entirely for my lord. My lord, we are only saying we have started.
Advise them. See,
No.
it
The
is,
order was
yeah.
passed in their presence on the
No, my
4th.
lord, may I indicate?
My lord,
We
today
have
we are on the
started,
11th.
my lord, today they can, my lord, today they have, yesterday they have given us certain documents. This needs scrutiny, my lord.
So there are two. Then what you should
Given the
say
documents
is,
on the 4th.
sir, please extend the time.
We have given the
This is
documents
what
on the
is
4th.
required to be
My
done.
lord, we had given the documents
My
on the 4th itself.
My lord, extend the time, my lord. This is my instruction. This will be complied with. This is not to offend the
All
court.
right.
My lord,
You
your
have
lordship
heard the
kindly
learned
see,
advocates of the parties.
the-
your lordship said in the
But
meantime,
they
they
are-
will
There
accept supply.
appears to be a
That has not been
a
said.
feeble attempt on the part of the appellant to re-argue the matter after the re-argue the contentions which were taken note of while passing the order dated 4/10/2023. This attempt, this feeble attempt of the appellant is not permissible and stands rejected. The learned senior advocate for the appellant submitted that the authorities are in the process of complying with the direction and request for a reasonable time. Let the matter appear under the same caption on Tuesday, and on that date, the authorities shall report compliance of the directions issued on 4/10/2023.
Very grateful.
My lord, may I only pray for one thing. They are insisting upon the contempt before the lower court. Now, my lord knows, my lord, that
You are
once.
saved from contempt there. Don't get yourself exposed from contempt here.
That is true. But my lord, kindly make an observation, my lord, both parallelly they cannot. They are.
I have already undertaken to your lordship that I'll
No,
not
no, my lord,
proceed
the
there.
last Friday the matter was there. This Friday, my lord, kindly make an observation, my lord, till.
All right. In the light of the above direction, the learned senior advocate for the appellant, the senior advocate for the appellant submits that the contempt petition is listed before the honorable single bench
This
on
Friday.
13/10/2023. The learned senior advocate appearing for the respondent submits that they will not press the contempt application on the said date and they will seek for an adjournment. The said submission is placed on record. Next, item 2.
Let the matter retain its position like your lordship.
Retain its position. We are
grateful.
I am appealing for Bhattara mentioned.
Yes, sir. Please come.
Rajib Mukherjee.
Where is Mr. Siddiqui? What is the order?
The order is at page 108 of
All
the
right,
stay
you have got the
application.
memo of appeal, right? No
My
problem.
lord, the order is
Relates to order passed by the chairman municipality for supply of LED street light fitting. Approval was for 19 schemes. Supply so and so. Petitioner was not paid. Places letter chairperson stating total amount 77.49 crores. Annexure. State raises an objection pointing out grant of approval.
Acknowledgement 94.
Deepak Kumar Mukherjee, Rajib Mukherjee.
Yes.
No, my lord, this tender was floated by the municipality. If your lordship kindly turns to page 32 of the stay application. This is for the purpose of setting up mechanism to convert all the sodium vapor, metal, CFL, GLS tube lights into LED. The petitioner was the successful tenderer, my lord. The petitioner was given the work orders. Work orders are annexed at several pages.
Doesn't matter. It's an admitted fact.
Admitted fact. Now, my lord, the petitioner says it is also an admitted fact, my lord. If your lordship kindly sees page 74, that the petitioner has carried on work of amounting to rupees 5,91,84,994. This has been issued by the chairman of the municipality. The petitioner says that you have paid me only 2.25 crores. The rest amount is still pending. Now the petitioner prefers a writ petition before this honorable court saying that the municipality is not paying for the work it carried out. This writ petition came up for consideration before this honorable court. The petitioner, apart from its due whatever was payable, petitioner has also relied upon
Page 95.
page 95, your lordship kindly sees.
Green City, though.
My lord, an administrative approval by the state of West Bengal, my lord, with regard to some green city mission project. The Honorable Single Judge, my lord, erroneously held that this work was carried out under the Green City Mission project. Because the Green City Mission project, if your lordship kindly turns to the next page, page 97, there were several works to be done under the Green City Mission projects. And serial number 6 and 7, if your lordship kindly sees. Supplying, fitting, fixing 17726 number LED street light under Green City Mission and development of street light under Green City Mission.
Yes.
My lord, the Honorable Single Judge that since this particular work was carried out under the aegis of the state for this Green City Mission project, therefore the state should be entitled to pay this amount.
Where is the tender document?
A tender document, if your lordship kindly
Page
sees.
32.
Page 32. If your lordship kindly sees the date, 12th of March 2015.
When was this Green City?
31st of July 2017 at page 95. Works have been carried out, if your lordship kindly sees.
According to the state, this is not falling in the Green City
Mission project.
Then the municipality has to pay.
Municipality has to pay. And if your lordship kindly sees only one letter, then my lord, I'm grateful to your
But
lordship.
then why did you affect the part payment of 2.
I did not. The municipality affected. Municipality affected.
Lord, I am appealing for the
Only one letter, my lord. Only one correspondence, page 112. This is issued by the municipality in reply to our email. With reference to your email dated so and so, I would like to inform you that all the above mentioned works received through email have been undertaken from SFC and 14 Finance Fund. The list of schemes which have been approved from BOC is attached herewith. The total work order is so and so, out of which order amount rupees so and so. You only have been cancelled and total up to date payment value is rupees this. At present, we have paucity of fund. That is why we are unable to pay the due amount right now. It is needless to mention that no AA, that is administrative approval, and financial sanction has been issued from the UDA and NMA department.
That is your internal problem, sir.
No.
Is he concerned about it?
No, he's not. The petitioner is entitled to that amount, but that is not my lord, the responsibility. The work has been taken.
Suppose the municipality does not have funds, then the state has to step in.
No, my lord. Under the West Bengal Municipal Act, it is the municipality which creates its own fund and pays for the works which is carried out. Only with regard to the work.
If you see the act, there is deep pervasive governmental control. On any local body.
This urban local bodies.
You can supersede the elected body. You can supersede. You can sanction funds. You can ask them to implement certain directions.
But if your lordship,
they are bound to implement.
No, your lordship, my lord, if your lordship kindly sees the West Bengal Municipal Act. It is the municipal.
And what is your stand, sir? Why you are not paying?
Lord, we have no lord. It is a state project. And we not state project is not done by visa municipality. It is state project. Lord, I will say.
See,
practically the lord state municipality is the one limb of the state government. Lord, remain without kindly see the tenure of the Board of Councillors is only for 5 years.
Alright,
Every 5 years they will go.
Let them go.
Let them go. I'm not there. I'm not there. I'm only to say.
All right.
But
chairman
Lord,
may not be
both
there,
may
sir.
come, both may go, but who state will go forever and running the municipality. Lord, I will show. Kindly see, Lord.
No, please hear us, sir. The elected chairman's term of office might have expired. That doesn't mean that the municipality has to be wound up. The municipality will continue. There will be an executive officer. There will be a commissioner.
Yes, and
So
that
therefore,
executive officer is
you are collecting.
is a man of below state government. Executive officer was appointed by the state government, and the panel was everything state government. And now, kindly see the
Now,
63A.
You have released 2.12 crores. And in the response, you are saying.
I have no power. Kindly see section.
No, why did you release 2.12 crores?
No.
Sir.
Kindly see, Lord, 73A. Kindly, take 73A.
The chairperson of the municipality has addressed or replied to the Additional Secretary of Urban Development and Municipal Administration Department on 9th of September 2022 that 2.18 crores has already been released, paid, and say the remaining amount, because paucity of funds, I am not able to do. Administrative approval has not been received. So if administrative approval is not received, this 2.12 crores should not have been released.
Lord, the fund comes from state government. My lord, kindly see 73, kindly 73A.
Genesis of the contract. Is of whose project? Genesis of the contract.
Which page, sir? Page number?
Lord, kindly 73A. First, Lord, kindly see 73A. I have no power.
Then how did you get the 2.1?
No, it is a blood. I have to take
They are only the executing authority.
executing authority.
Executing authority. Project is the state government project.
State government project, everything is done by blood. This
Government project. is-
municipality is implementing.
We are the local authority. We are the only
But
implementing.
your
the
tender
things.
doesn't say so, sir. Your tender at page 32 says, who's the tender inviting authority? It is the municipality.
Definitely, Lord. Tender will.
My lord, project is the state government project, or either state government project or central government project. The executing authority is the local authority, municipal authority. My lord, fund created by any project. Suppose after 74th Constitution Amendment, municipality become a state under the limb as a limb of the state of West Bengal or under the control, my lord. Prior to the 74th Constitution Amendment, the municipality is the local authority or urban authority. Subsequently, any project, any central government project or state government project or any fund given by the UNO, what is the charitable purpose, all are given through the Minister of Finance, then Municipal Affairs, then Director of Local Bodies, then municipality will come. And audit portion is the hand of the state government. All burden lies.
Now, this 2.12 crores which was paid from the government funds or from the municipal funds?
Is a fund allocated by the state government and municipality disburse the same.
Where do you get it? You have not placed any document to the said effect. Because if you please turn to page 112, 112. But one thing, Mr. Chaudhary.
Yes, my lord.
This is a money claim.
Yes, my lord, it's an admitted money claim.
But even assuming so, how a writ petition was maintained?
Yes, my lord,
is a commercial
there are
court
judgments, my lord. It's my
Commercial
lord,
dispute.
arbitrary and illegal to retain money in this way, my lord. After having admitted, there is no, my lord, difficulty there. There's a complete admission that we have to
But
make.
if it is a government project,
It's not a government project, my lord. That is what I have been stating.
no.
It's never been a government project, municipality
But
by itself.
your learned friend says that this
But that is-
2.18
That is
crores.
what I am inviting my learned friend, where it is the government project. The government project started from 2017
70.
and the work order was issued in 2015.
All
The
right.
work was-
They had the forethought even much earlier. You appreciate the municipality. They wanted to
even-
go green even before the government thought of
Even
green.
section 73, my lord, cannot come to the rescue because this is, my lord, even section 73A,
But
which is,
if they don't have funds, what to do?
Good.
You substitute
my
them.
lord, but at the present moment, my lord.
So what you can do is, like you have subsidized for the, what is it, tram company, tramways company, transport corporation, they are with lack of funds. So what the government does is, it extends a sort of a loan against a charge.
But-
And as and when the property taxes, etc., revenues are collected, that will immediately stand transferred to the government. So that exercise you do.
No, for that purpose, they could have approached the authorities that we do not have the fund. You kindly give us something. We want
Because
as a loan.
a project of such nature, obviously it will be in excess of the fund allocated to the municipality or allocated for that particular purpose. This is something like citizen-centric or public service. So therefore, obviously they will not have 8 crores or 10 crores only for street lighting. They have got a lot of other work to do. So that is the reason they seek for administrative approval from the government. In the event of a funds crunch, they will have to come to you with a begging bowl. So you need to relinquish it Thereafter, recover it from him.
I'm grateful to you, my lord. They could have approached us, said that
We
are
will
going,
say that now.
we seek your administrative approval. We are allotting this work to this person.
Sir, now work has been done, part payment released. At this juncture, we have to infer that administrative sanction or approval is deemed to have been granted.
My lord, this way,
Then
my lord,
Otherwise,
I'll
look
tell
at
you- I'll
our
tell you- I'll tell
situation.
you also, no,
We've
he is
imported
entitled-
these bulbs
No, no,
and
he
we've
is
put them
entitled,
out
my
on the road.
I have,
And my lord,
my lord,
state has to
not
pay
come,
for it.
I have not come against the writ petitioner, my lord. He is entitled to his amount because he has carried out his
All
work.
right, now
My lord, what
you
I
are more
what I-
concerned
my lord, if your
about
lordship sees, it opens the floodgate. Each and every municipality, then my lord carries out work without the administrative approval and then say, my lord, give me
all
the money.
right, your chairman is elected chairman is your man.
Not necessary, my lord, not every time.
So what we can do is you are more worried about the contempt petition, your officers to appear. What we will do is we will direct the government to release the funds subject to the condition that this shall be treated as a loan towards the municipality and the amount shall be recoverable from the municipality by the government in the next budgetary allocation. That will be the best thing. Win-win situation. You are also saved. You will get the money, but for the present, because this is like I have done with a batch of cases where the State Transport Corporation, they did not release the pension for the retired employees. So the entire state, the dues were about 1,800 crores. None of the state corporation, every state corporation was running under a loss in each of the districts. So what else to do? So the division bench passed an order that the state has to step in. So because it is being manned by an IAS officer who is the managing director, etc., and whatever was recoverable, because there was a fund was created for that purpose, and the corpus was contributed by the government, and that will be a charge on the corporation. And whatever was recoverable by ticket collection, these advertisements, etc., and the corporations will, at the rate of probably 30% of their total revenue per month, will stand remitted to a particular head of account. So it took probably 1.5 years for the government to recover. All employees got the pension. Only thing is we interfered with the interest component because they were entitled interest, they were not able to pay, and installment was granted. 3 installments or 2 installments, matter got dissolved. Otherwise, you need to save, or you dissolve the municipality and you take over. Once you take over, the liability is yours. Because under the Act, any municipal corporation Act, the control is deep and pervasive. Though they may be under the Constitution, a self-governed, what is it called?
Local body.
Local body, self-governance, the panchayat, Jilla Parishad, etc. But still, if they pass a resolution, it requires the approval of the government.
Lord, this is a
Lord,
regular
that-
problem,
that is the
which my lord citizens face. If your lordship
lord, if
looks at my lord panchayats and municipalities, they're always crying that we don't have money. Trying to take taxes, trying to, my lord, going and collecting, my lord.
Let us see under the Act, the powers of the government. Page 210.
Section 67, 68 and 69 talk about municipal fund. Even 70.
Uh, 72.
The 70 is not earmarking of a fund for a purpose. So
71, 72.
that is the extent of their control.
72 deals with loans.
Yes, 71 financial assistance.
This is giving of grant of financial assistance.
Basically, we are trustee.
71.3, my lord, if this is part of the annual development plan, it's it's a state's obligation.
Section 2, you see, state government may advance from the public funds or stand as guarantor for funds from any financial institution. So they are empowered to avail loans, and the government, with the permission of the government, and the government will stand as a guarantor. State government may require municipality to observe such financial disciplines also.
Lord, even my lord 71, if your lordship sees, financial assistance from the state government may give grants or financial assistance to a municipality with or without direction as to the manner in which the sum shall be applied. State government may also lay down a pattern for distribution of such grants or assistance.
Grants are basically for those pensions and all this municipal employees.
And then, my lord, the state government shall give grants to a municipality or notified area authority for implementation in full or in part of any scheme included in the annual development plan. My lord, development, my lord, is really to be backed by the state.
But for that purpose, the approval has to be taken.
But
If you come to chapter 28, starting from section 425, enormous power is there. (429)B, in discharge of their functions, the municipality shall be guided by such directions as may be given to them by the state government in conformity with the provisions of this act. Now these bulbs would have lost their life and it should have been time for replacement.
Yes.
Their life is probably 3 years.
3 years or 4
Now
years.
they are also maintaining it possibly subject to correction. There were two conditions.
Because what happens is slowly the what is
LED
it? The
power is
power
reduced.
or the illumination slowly starts
decreasing.
It doesn't like a normal tungsten bulb. It doesn't get fused. Slowly, like a candle, it will. Now, when your secretary has to appear?
After tomorrow.
But we have not seen your urban development secretary.
No, it is the rule has been issued against the joint secretary and the commissioner of the urban development.
Commissioner of?
Joint secretary and the commissioner of the urban development department, both of the urban development department.
This intra-court appeal by the state is directed against the order dated 23rd November 2022 and WPA 37 of 2021. The respondent writ petitioner filed the writ petition for expressing a grievance regarding non-disbursements of the amounts payable to the writ petitioner for having successfully completed the work allotted, work allotted to them pursuant by order dated 12/3/2015, pursuant to a tender invited by the respondent municipality. The tender was for conversion of all sodium vapor / metal / CFL / GLS / tube light into LED. It is not in dispute that the writ petitioner has completed the work to the satisfaction of the municipality, since part of the amount payable towards the work done to the tune of rupees 2,18,23,927 has already been paid to the respondent writ petitioner. Since the remaining amount was not paid, the petitioner approached the court, and the learned writ court, after taking into consideration the facts, found that the claim of the writ petitioner was not in dispute. Therefore, proceeded to issue the impugned direction. The grievance of the appellant state is that the project undertaken by the municipality is not a state project, nor it is a project under the Green City Mission, which was put in place only in July 2017. And the learned single bench fell in error in coming to a conclusion that the project for which tender was awarded to the respondent writ petitioner in the year 2015 was a Green City Mission. Therefore, it is submitted that direction could not have been issued to the state government to disburse the funds, and it is the lookout of the municipality to pay the amount due and payable to the respondent writ petitioner. we have perused the order granting administrative approval for the schemes under this Green City Mission dated 31/7/2017. From the said communication, it is seen that the works which were work for which the amount was from which it is seen administrative approval in respect of 19 schemes for the respondent municipality at an estimated amount of cost of rupees 13,94, 69, 745 has been granted by the government, and the work has to be executed by the respondent municipality. Admittedly, the work was allotted to the writ petitioner in the year 2017, and in all probabilities, the same could not have been covered in the Green City Mission project, in the schemes under the Green City Mission, for which administrative approval was granted only in July 2017. Be that as it may, since the amount due and payable to the respondent writ petitioner is not in dispute, the amount needs to be disbursed. The learned advocate for the respondent municipality submits that there is paucity of funds, and it is and the project was implemented only out of the amount sanctioned by the government. However, to substantiate the same, there is no document placed on record. However, on perusal of a reply given by the chairperson of the municipality to the additional secretary of the Urban Development and Municipal Administration Department, Government of West Bengal, dated 9/9/2022, we find it is seen that the chairperson of the municipality has stated that administrative approval and financial sanction has not been issued by the Urban Development and Municipal Administration Department. If that be so, obviously it goes without saying that the project could not have been implemented without the government approval or sanction. However, the project has been implemented and completed, and part of the amount payable to the writ petitioner has also been paid, which would go to show that the project is deemed to have been approved. The project
class 12 examination
is deemed to have been approved, and more particularly when the schemes have also been approved by the Board of Councillors of the municipality. Since the municipality pleads paucity of funds, a workable solution has to be conceived in this matter, so that the writ petitioner is paid the balance amount. Considering the scheme of the West Bengal Municipal Act 1993 and the various provisions therein, especially Section 71 of the Act, 71 and 72 of the Act, which deals with financial assistance from the state government and loans respectively, as also the powers of the state government as contained in chapter 20.
Section 425, chapter 28.
As you've seen from chapter 28, and more particularly section 429 capital B, 430, 431, it is seen that there is a deep and pervasive control, governmental control over the municipal administration. Therefore, we are of the view that the government should sanction the requisite funds as a loan to the municipality and the same can be recovered from the municipality in a phased manner or as the government may desire. In order to give effect to such a direction, reasonable time has to be given to the government so that the necessary funds are sanctioned to the municipality with a direction to effect payment to the respondent writ petitioner, and also placing conditions as to how the money which is sanctioned is recovered from the municipal funds. Accordingly, the order and direction issued by the learned single bench in the impugned order is slightly modified by directing the appropriate authority of the government of West Bengal to sanction a sum of rupees 366,04,735 to the respondent municipality within a period of 6 weeks from the date of receipt of the server copy of this order. On receipt of the funds, the municipality shall disburse the same to the respondent writ petitioner and obtain a no due certificate from the respondent writ petitioner. The state government is at liberty to pass appropriate directions while releasing the funds as to how the funds are to be recovered from the municipality, either in full or in installments, as the government may so desire. With the above observations, the modification made to the order passed by the learned single bench, the appeal stands disposed of.
But only
in order to effectively implement the above direction, the municipality is directed to immediately address the government based on the orders, based on this order, and seek for necessary allotment of funds so that the order can be complied with within the time stipulated. Yes, sir.
Only, my lord, one aspect, my lord, your lordship may kindly record, my lord, the work should not have been taken, my lord. This work should not have been allotted without prior approval by the government.
We have said deemed approved.
Let your lordship may kindly, because this will open a Pandora's box, my lord. But get, my lord, because all the municipalities will start.
Mr. Siddiqui learned government council submitted. Submitted that the work should not have been allowed to be commenced without obtaining approval from the state government. One line. Next.
My learned friend says that you are getting light.
You're getting light.
At the end of the tunnel.
My lord, one line, my lord, subject to question in the order, your lordship has mentioned, my lord, that admittedly the work was awarded to the petitioner in the year 2017. It should be 2015.
2050.
Sir, I'm grateful, my lord, to Mr. Siddiqui for his fair stand.
Yes, yes.
He did not, my lord, object to, my lord, money being paid to
He
me.
is entitled to that.
But every time this is a problem. Every time this is a problem. Our proposals also, they get stuck. Then if suppose we contact the concerned secretary, they say, no, the contractor will implement it. No administrative approval granted. Or administrative approval is granted, financial approval is not granted. If both are granted, fund is not sanctioned. Yesterday also I am dealing with one matter. The annual maintenance, that was, as a result of which, what happens? The contractor does not execute the work, or if the work is midway, let us say, he doesn't pay those laborers or workmen who are engaged in the.
Well, if it has been accorded approval, it has to do that. But this aspect, well, I think it otherwise. My perception with regard to these works.
Lord, on a lighter note, my lord, the same is the fate of Mr. Siddiqui's memos also, my lord.
Even I'm told income tax panel councils are also suffering.
My lord, I am his predecessor in interest, so I am aware.
He knows it very well.
You file a writ petition.
No, Mr. Chaudhary never needed any money at all.
Several petitions were filed before this court, when the lawyers were there attached with the erstwhile.
Now you file a writ petition.
I will move it for you.
Yes. No, it has been done. I have passed around 6 orders. They took it to Supreme Court also. Supreme Court only interfered on the rate of interest.
But to be very candid to your lordship, my lord, one honorable judge who is not there before in the Supreme Court, my lord. My lord, the writ petition was filed. I appeared for the state. I raised an objection saying that a writ petition is not maintainable. The honorable judge, my lord, told me that Mr. Siddiqui, a day will come that when you have to stand
You
for
will
this.
have to. No, in fact, additional advocate generals have also come to court saying that no
Now,
income
my
tax.
understanding, my lord, he did.
Income tax panel is
But
also.
to be fair, my lord, my lord, was there for 5 years. I have nothing outstanding. I resigned and my lord, because of the pressure of private practice, I have nothing outstanding. To be very
Mr. Chaudhary was never into money, my lord. He had enough. He didn't want anything more. Not the case with everybody.
No, filing expenses, out-of-pocket expenses, clerkage, all this has to be given upfront, sir. You can't expect a panel counsel or a government counsel to spend out of his pocket.
Especially those who are advocates, my lord, who are there as group A, B, C, my lord, in the lower tiers, my lord, they are not paid anything.
No, if you seriously saying, if you file a writ petition, we'll do something.
But my lord, he has said that, my lord.
Or you write a letter, we'll treat it as a plea. That will be easier.
I'm grateful.
And we'll ask AG to appear and let him answer then within what time frame he is. Yes, original side now.
Only the next matter on the appellate side, item number 3, not jointly, we are praying for next week. Right?
Next week.
Item number 3.
No, let it remain in the list. Don't take.
Tomorrow, there is some difficulty for next Tuesday, Wednesday, not whenever it comes.
But actually, may I make this submission? There is no urgency as such.
There is.
The NOI has already been
All right. As
awarded.
jointly prayed, item 3 next week.
Grateful.
In the appellate side. Huh? Item 4, what is item 4? Oh, that is SGS.
Item 4, my lord, I appear, my lord, on the last occasion, led by Mr. Chatterjee. On the last.
The Lordship wanted us to, my lord, get an instruction written that my lord, the debarment is only for this tender or not. That is with Mr. Kormakar, he may hand it up to your Lordships. We've said that it's only for this tender and not for, my lord, the all tenders. He's free to, my lord, do his business.
Lordship, I appear for the private respondent in this.
You have a copy of this?
Yes, sir.
You have a copy, so they can.
Sir, what we'll do is we'll
But
pass
have
a
a copy.
Yes,
show it to senior. Let him read.
No, it has not been appealed by the solemn High Court judges.
Pardon?
High Court judges has not referred to
No,
it.
you see the next line. Probably his understanding is that. That's all.
That's a particular.
That's an unnecessary statement
So,
made.
therefore, we protect
In
you
a
for
way,
the present by passing an order that they have clarified that this disqualification is where the particular tender will not operate as a bar for the appellant in any other tender.
Lordship, already in draft order, Lordship mentioned that. My lord can see my lord draft order.
In the last order.
On a prima facie reading, now we will affirm that.
Please, that when my lord only to have one thing, they have to clarify also, it does not mean I have been empaneled from 2016. It doesn't mean this re-empanelment. My empanelment is not cancelled by this.
Yeah, they are more concerned saying that you are trying to create a
Because can we add? There also doesn't mean
your client's
cancellation of empanelment.
Your client's credentials are not in doubt.
Not
But then Pan India, they're or internationally also they're a very renowned certifying agency. There's no doubt. But their contention is you are trying to create a monopoly.
Yes.
And other government agencies.
All right. We for the
doesn't mean it. And giving me that the hearing.
12/10/2023, we expressed a prima facie view that
cancellation.
The communication dated 5th January 2023 pertains to the particular tender and cannot be read to mean as if the appellants have been blacklisted by the Jute Commissioner or to be treated as a general disqualification, disqualifying the appellant from participating in any of the tenders which may be invited by either the state or central government agencies. The learned advocate for the Jute Commissioner was directed to get appropriate instruction. The Jute Commissioner has given written instructions dated 10th October 2023, from which it is seen, from which it has been admitted that the disqualification pertains only to the particular tender dated 2nd February 2022. And it in no way is meant to be a general disqualification or any blacklisting of the appellant/writ petitioner. They said instruction date given by the Jute Commissioner dated 10/10/2023 is placed on record, and it is clarified that the communication dated 5th January 2023 is confined only in respect of tender number so and so, dated so and so, and it is in no way meant to be a general disqualification or any blacklisting of the appellant/writ petitioner. Let the matter appear.
Kindly add,
immediately.
kindly add, fix the appeal on the first Monday after reopening. And but kindly add one line.
We'll have it on 4th December, sir, because in between there are holiday. 4th December. 4th December. 6th December. List
Not
the matter on 6th.
earlier, not possible. Because they might kindly add one line that this disqualification doesn't mean cancellation of impanelment.
No, that is that is the
Well,
case.
latest
That is our case.
We'll
Impanelment
consider
change.
others are coming.
Yes.
Other government agencies.
That we
the
have
qualification
clarified. That we
is
have-
impaneled with the justice.
Next.
They might kindly fix it on first Monday, my lord.
No, that we have added. That is sufficient, sir. Next. What is it? Original side. Original side.
Grateful, Your Lordship.
Original side daily list, item number 1.
My lord, appellate side item 5 was, my lord, the one I mentioned yesterday, my lord.
Item 5.
My lord, item 5, my lord. I had mentioned yesterday.
9 or 5?
5, my lord, 5.
And you are appearing for 5.
5 of appellate side, Lordship. Yes, I am for the state, Lordship.
We'll take up that matter. You will take item 5 of appellate side and then we'll come. Siptesh.
Well, I am the respondents below the company.
My lord, my homestead land, my lord, is sought to be used as a high tension electricity corridor, and while doing so, my lord, certain provisions, mandatory provisions have been given a complete go by of the statute. My lord, I come to know of it in the last week of August. I give a representation.
But when by the time you file the writ petition, the court says 99% of the
My lord, I am aware of it, my lord, but I'll just place something. My lord, this is a expropriatory legislation, my lord. My lord, section 10DB has to be given a strict construction. Section 10D, my lord, will kindly come to section 10D, which
by
says,
erection of the high tension line tower, your right to use the land is in no way affected.
It is
that has been settled by the Supreme Court. Are you carrying the decision which arose from the Andhra Pradesh High Court? Some poultry.
my lord, I'm conscious of that. My lord, I'll just
So
therefore point
therefore,
out, my lord,
the window given to the court to interfere is very, very, very narrow.
I'm aware, my lord, but I'm just conscious, my lord, what is it, my lord? My lord, this is, my lord, my land is, my lord, it opens to the high road. My lord, my land is homestead land, my lord, the land beside, my lord, the land beside adjacent is a low land, my lord. My lord, it could have been jolly well taken
But
through that.
what were you doing all these days?
My lord, it is, my lord, that is, my lord, I have come to know of it now, my lord, when they were
99% means now it is 110% complete.
understand, but my lord,
The line would have been
subject-
energized.
My lord, subject to correction. My lord, can there be any estoppel against the law? My lord, something which has to be done in a manner has to be done in that way. My lord, section 10
Yeah,
makes it mandatory.
If the litigant is not vigilant, he doesn't
My lord,
require.
certainly, my lord, I bow
In
down
the
to my lord
year
on that, my lord.
21,
My lord, 2021,
1921,
not
everybody was informed.
2021. 1921 only khate hoye. My lord, 2021. My lord will kindly come here. My lord will see. My lord, it has been laid down. My lord, what has been impressed upon by the court, my lord, that they had been offering me 75 lakhs, and just to twist a higher bargain of 1.1 crore 2 lakhs, I have not done that. But that has been submitted by them without rehearse any record.
We have not offered anything because the law says, absolutely below law says, that after completion of the work.
What was submitted by him in the court below, my lord?
What about compensation?
Compensation, we are agreeable.
Compensation. I'll just
We asked them to come here, they are asking for some crores.
I'll just indicate, my lord. I'll just indicate. My lord will kindly come. Kindly appreciate few Supreme Court judgments. My lord, I have, my lord, I'll just, my lord, expropriatory legislation, my lord, has to be given a strict construction in my favor. My lord, my rights cannot be brushed aside. My lord will kindly come to section 10D, which says it shall. My lord, the statute is very conscious of the situation. My lord will kindly section 10D. My lord, if I may.
Telegraph Act.
Telegraph Act.
Well, section 10D has two parts. One, the latter part talks about the compensation, and the former, my lord, it says in the exercise of the power conferred by the section, the Telegraph Authority shall do as little damage as possible. My lord, this cannot be brushed aside, my lord. My lord, it could have been taken, it could have been, and moreover, my lord.
Yes.
Well, this 10D. In the exercise of the powers conferred by this section, the Telegraph Authority shall do as little damage as possible. My lord, will kindly now come to the impugn order, my lord. It has been, my lord, I had canvassed before the the court below, my lord, paragraph 4. It is submitted that such steps on the part of the transmission licensee would have lessened the damage caused by the petitioner. My lord, this is, my lord, will find at page 86 of my lord. This is the internal page 2 of the impugn order. So, my lord, it is admitted position that it could have been taken by a land which is of less value, just adjacent to my land. My lord, this point was taken. My lord, I was just given 3 days notice before DM gave me a hearing. My lord, the statutory authority, before statutory authority gave me a hearing, I was just given a 3 days notice.
But at this juncture,
my lord, I understand.
We can't set the clock back.
My lord,
we will direct them to give you a hearing. You make your claim for
this hearing, my lord, before 10D, my lord, what they have sought for. When I put up a resistance and when the statutory authority is supposed to give me a hearing, my lord, an order has to be culminated from there from. My lord, no order has been passed. That they are rejecting me, that they are doing, they are accepting my arguments. My lord, nothing has been done. My lord, all steps can't be jumped across, my lord. My lord, and my lord, this is an expropriatory legislation. My lord, I'll just read. My lord, property rights. The Supreme Court has gone to the extent of saying that
no. There are umpteen number of decisions. Your right to property has not been enjoy the property has not been affected.
My lord, it is. My lord, it is
by a transmission. That is your perspective. Law is different. Law is, they have said your right to ownership or enjoyment is not affected by putting 4 legs of the transmission line or 6 legs. But if there is a damage to standing crops, damage to building, you are entitled for compensation.
Yes, my lord.
And in certain other cases, they have also extended free agricultural service connection supply to the persons whose in the agricultural line. That is the scheme is there.
My lord, I'm conscious. My lord, I'm conscious of this judgment. My lord, this high tension.
So you get good compensation and be happy.
My lord, that
probably you give him some free electricity for his house.
My lord,
you can give free electricity for his house.
My lord, the high tension is such. My lord, my homestead land, the nature of the land is such. I will get a G+4 over there. My lord, that is 15 meter. And my lord, I can show, my lord, if that be so, my lord, if that is the case, my lord,
all right, you will also be benefited. Ultimately, the transmission line may benefit several hundreds and thousands of people.
Public interest pitted against my individual right, my lord, that is true, my lord. But behind the smokescreen of public interest, my lord, if I may use the term,
you come forward with a better case. We will go into all these decisions, but not in this. It's a very hard case on facts. 99% is over.
99%,
the line has also been energized.
Put forth any record, they had not been doing just after the impugn order. They had hung up the wire above.
Please come. We have heard the learned advocates for the parties. This
they have made.
Is directed against the order
that they are offering 75 lakhs in the single bench.
In WPA 23088.
The district magistrate orders is yet to be passed, my lord. Which is supposed to be under section 10D.
By contending that his homestead land has been affected on account of erection of a high tension electricity transmission tower through which the transmission lines are drawn. The learned single bench, after considering the facts of the case, more particularly that the project has already been implemented to an extent of 99% and the line was to be energized, considered held that the petitioner would not be entitled to object to the entitled to seek for shifting of the tower or the transmission line. However, the learned writ court, in our view, rightly directed that steps should be taken for grant of adequate compensation to the appellant writ petitioner, for which an opportunity of hearing was directed to be granted to the appellant, preferably within 1 month from the date of the order. The learned advocate appearing for the appellant would vehemently contend that the provisions of Section 10 of the Telegraph Act,
Section 10D, my lord.
10 within bracket small d of the Indian Telegraph Act 1885 has been given a go by, and no orders has been passed by the district magistrate, despite the objections raised by the appellant. Further, it is submitted that in terms of the said provision, the telegraph authority shall do the authority shall do as little damage as possible, and in the instant case, the appellant cannot put to use the homestead land on account of the transmission tower / line, and if the tower was not erected and the lines were not drawn, the appellant could have even constructed a building consisting of ground plus 4 floors. All these contentions ought to have been raised by the appellant at an appropriate time, and the appellant is had grossly delayed the matter, and after completion of the work of up to 99%, and at the stage of energizing the lines, the petitioner has approached the court. Therefore, the learned writ court rightly took into the consideration the public interest involved in providing electricity for the entire district, pitted against the interest of the appellant / writ petitioner, and declined to grant relief with regard to shifting of the transmission line. In our considered view, there is no error in the observations made or the findings recorded by the learned single bench for us to interfere. However, as directed by the learned single bench, the
it was on 9th, my lord, while we had preferred an appeal, my lord, the hearing was given to us on 9th, my lord. We could not, we had appraised them that the matter is pending before the court. My lord, in that case, my lord, considering all this, my lord, at least, my lord, that, my lord, we record that, my lord, this has to be given, my lord, let these be considered, and my lord, they had, my lord, he had,
however, as directed
it was said that they had.
A hearing was fixed on 9th October 2023, but on account of the pendency of this appeal, the appellant could not participate in the said hearing. The concerned authority of the respondent department is directed to fix a date, a fresh date of personal hearing, preferably on between 16th to 19th October, and the appellant shall be heard out on the said date, and thereafter the claim for compensation shall be decided, and a reasoned order be passed on merits and in accordance with law within a period of 3 weeks from the date on which the personal hearing is concluded. Thank you. Next, you come back to original section. Dismissed with observation. Yes, item 1, Mr. Tilak Mitro.
May it please your lordship.
You are all right now, sir?
I am recovering now.
Recovering.
I am for the respondent, my lord.
Any stop.
There is a delay of this is with yes, delay will be fasting my lord.
It was served 9 months before COVID period, and after COVID period also 16 months thereafter, and no reason at all.
But in apart from that, my lord, on the merit of the matter, I believe, my lord, there are the point is, my lord, the cancellation of the registration, my lord, on the ground that the accommodation entry was done. So even on that score, my lord, I really do not find, my lord, anything, my lord, which can be placed.
You have heard Mr. Tilak Mitro, Senior Standing Counsel for the appellant, and Mr. S.M. Surana, Advocate appearing for the respondent SSC. There is a delay of 1,378 days in filing the appeal. On perusal of the petition, we find no acceptable reasons have been given for condemnation of the inordinate delay of 1,378 days. Therefore, the application is dismissed. Consequently, the appeal stands rejected. The substantial questions of law suggested by the revenue are left open. Next.
Item number 2.
Regarding the issue relating to this fees,
Yes, we will take it up in some appeal instead of condone delay petition.
whatever ballot is.
Today, any appeal is there? We'll just, what is this? 657 days.
My application here. On the last occasion, there was a direction for serving a fresh your lordship, and the departmental people, they have already through mail your lordship with this stay application, and the memo of appeal along with the section 5 application has already been served.
So, Mr. Roy Chaudhary, where is that letter which you had given?
We are carrying that.
We have heard Ms. Smita Das De, Learned Senior Standing Counsel for the department. Notice has been sent by the DCIT Circle 11, Kolkata, to the assessee, informing that the application will be heard by this court. However, the assessee is not represented. In order to afford one more opportunity, we are inclined to adjourn the matter. While hearing the matter, we have also, while hearing the learned standing counsel for the appellant department, we have also heard the other panel counsels who are present in court. And the court was surprised to note that the fee payable to the standing counsels has not been settled. And there are a lot of issues relating to the same, which needs to be resolved by the income tax department. In this regard, a detailed representation has been given by all the panel counsels to the Commission of Income Tax (Judicial), Kolkata, on 18th August 2023. And it appears that the said representation has not been disposed of or considered by the department till date. On an earlier occasion also, this court had during September 2022, this court had an occasion to deal with the identical issue, and after certain directions were issued, the issues appear to have been resolved. However, now the allocation of cases and the fee payable to the standing counsels are to be done by the income tax department, and as the matters have been hived off from the Ministry of Law and Justice and exclusively allotted to the income tax department. Therefore, we direct the Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, and the Commissioner of Income Tax Judicial, Kolkata, to consider the representation given by the standing counsels dated 18th, received by the department on 18th August 2023, and file their response. The response should be in the nature of resolving the present impasse, and also to protect the interest and dignity of the panel counsels who are appearing for the department in several cases.
Okay.
Let such report in the form of an affidavit be filed by either the Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, or the Commissioner of Income Tax Judicial on the next hearing date. Let the matter appear under the caption for orders on 18/10/2023. The learned advocate for the appellant department is directed to communicate this order along with the copy of the representation received by the Commissioner of Income Tax Judicial on 18/8/2023 for compliance of the above direction.
May I file a further notice to the SSC because already we had, this is the second time.
No, we'll wait. Let us see on 18th. Who appeared before for the SSC in the
Some
time?
D. Shah, my lord.
Miraj D. Shah.
Viraj D. Shah.
Then you tell Junjunwala. You tell you take instruction. Next Wednesday, it's coming.
Item number 3.
$27 days. We can
Yes,
come.
my lord. There.
Carry forward loss.
Yes, ma'am.
Indus means the beginning itself. Assessing also justified disallowing.
But the issue now stands covered by your lordship's own judgment. These are limited scrutiny converted into complete scrutiny without the approval of the competent authority. My lord, unfortunately, my lord,
CBDT instruction is
yes, my lord, unfortunately, we are not carrying the hard copy of the judgment. Well, may I just hand up the soft copy of the judgment?
Mr. Sharma, you are aware of this.
My lord, I have only one point. I will make submission only on one point, my lord.
Lordships have held. But in that case, my lord, there was approval was granted, but it was a post facto approval. In this case, admittedly, there is no approval at all.
Tribunal has said so.
Yes. We have got the hard copies of the judgment.
Only upon conversion of such a case to a complete scrutiny after following the procedure, the AO may examine the issues other than the issues involved in the limited scrutiny. On facts, it is.
My lord, one submission, ma'am. I will make, if I can satisfy my lord.
Yes.
My lord, the so-called notice was issued to the SSC on this point.
On this point.
And SSC had given its response and categorical response. And those responses were dealt with by the assessing officer and disallowed the set of losses. The SSC challenged that assessment order before the commissioner. There, so my lord, here the SSC had submitted itself to the jurisdiction of the assessing officer and participated in the, did not raise this point before the assessing officer, nor raise this point before the commissioner of appeal.
They are also on merits, they argue.
On merits.
No,
thereafter,
commissioner we argued on merits, right?
That appeal of the SSC was partly allowed by the CIT appeal. Being aggrieved, the SSC challenged that order before the tribunal. In the tribunal, for the first time, the SSC raised this point as an additional ground. So, my lord, my respectful submission, my lord. Once
But
the SSC had,
if it is a jurisdictional issue,
my lord, in the first instance, the SSC had waived that by participating in the proceedings, submitting to the jurisdiction, and now the SSC cannot challenge the jurisdiction.
but estoppel is difficult.
Well, in fact, my lord, subsequently in 2017, well, we have the soft copy of the circular. Another circular has been issued by the department, taking a very stringent view. And in one case, my lord, it has been recorded in the said circular. You have got the circular? Get me the circular. Now, kindly take the circular. My lord, it has been recorded in the said circular that disciplinary action has been initiated against the assessing officer for
traveling beyond the limited scrutiny. This is a 2017 circular. Taking note of the last 3 circulars.
Poor fellow,
Okay.
he is suspended.
Yes.
Instances have come to notice of CBDT. Some assessing officers are traveling beyond their jurisdiction while making assessment in limited scrutiny cases by initiating inquiry on the new issues without complying the mandatory requirement of relevant CBDT instruction dated so and so. Instances have been viewed very seriously by CBDT. The Central Inspection Team was tasked with the examination of the assessment records and receipt of allegations so and so. Among other, it is found that no reasons have been recorded so and so. Officer concerned has been placed under suspension.
So, my lord, this is an irregularity. So, my lord, if I propose
But it's not, it's an illegal.
Yeah. My lord, it can be remanded back to the assessing officer.
He'll consider. Please come. We have heard Mr. Amit Sharma and the Senior Standing Counsel for the appeal. Is Rai is also there?
No, my lord.
And Mr. Abrudosh Mazmundar and a senior advocate appearing for the respondent. There is a delay of 27 days in filing the appeal. We are satisfied with the reasons assigned in the petition, and the delay in filing the appeal is condoned. Application allowed. Para. This appeal by the revenue is directed against the order that is by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated 28th March 2023 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA number 753/KOL/2019 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page number 6 and 7, A and B. We have heard so and so. The short issue which falls for consideration in the instant case is whether the assessing officer exceeded his jurisdiction in completing the assessment on grounds which were not subject matter of the limited scrutiny. The contention of the learned standing counsel for the appellant is that the assessee was put on notice on that particular issue by the assessing officer, the assessee participated in the proceedings, and thereafter the assessment was completed. Assessment was completed by order dated 27/12/2017 under section 143 within bracket 3 of the Act. The assessee carried the matter on appeal before the Commission of Income Tax Appeals 5 Kolkata CITA within bracket, and no such content, and the appeal was contested on merits, and the appeal stood partly allowed on certain issues by order dated 14/1/2019. The assessee being aggrieved by the disallowed portion of the order passed by the CITA preferred appeal before the tribunal, and in the appeal additional ground was raised contending that the action of the CITA in confirming the action of AO assessing officer in making additions in respect of issues not mentioned in limited scrutiny were beyond jurisdiction of assessing officer, as the scrutiny assessment was selected for limited scrutiny under section 143 within bracket 2 and not complete scrutiny. The department objected to the additional ground which was raised by the appellant before the tribunal. However, the tribunal overruled the said objection, contending that, holding that the issue is a jurisdictional issue and can be raised by the assessee at any point of time. This finding of the learned tribunal is well justified and in accordance with the settled legal principle. Thereafter, the learned tribunal has examined the re-examined the factual position and found that the issue which was decided by the assessing officer was not part of the limited scrutiny for which the assessment was directed to be scrutinized. On facts, there full stop. That apart, the learned tribunal has also taken note of the CBDT instruction. Ajahn, open the circular.
My lord, this instruction was
This one, CBDT instruction number 5 of 2016 to hold that the assessing officer has exceeded his jurisdiction.
এটা না
The learned senior advocate appearing for the respondent assessee
this instruction.
has placed
ওটা আর
before
ওটা
us
দুটোই
placed before us another instruction issued by the CBDT dated 30th November 2017 in F number DGIT within bracket VIG/HQ capital /SI/2017-18, wherein the CBDT has noted instances where some of the assessing officers were traveling beyond the jurisdiction while making assessment in limited scrutiny cases by initiating inquiries on new issues without complying with the mandatory requirements of the relevant CBDT instructions dated 26/9/2014, 29/12/2015, and 14/7/2016. It has been stated that these instances have been viewed very seriously by the CBDT, and in one case, the central inspection team of CBDT was tasked, TASKED, with examination of assessment records on receipt of allegations of several irregularities. And among other irregularities, it was found that no reason had been recorded for expanding the scope of limited scrutiny, no approval was taken from the PCIT for conversion of the limited scrutiny case to a complete scrutiny case, and the order sheet was maintained very perfunctorily. PERFUNCTORILY. Further, the CBDT has recorded that this gave rise to very strong suspicion of malified intention, and the officer concerned has been placed under suspension. Therefore, it was reiterated that assessing officers should abide by the instructions of CBDT while completing limited scrutiny assessment and should be scrupulous about maintenance of note sheets in assessment folders. Thus, considering these aspects, we are of the view that the learned tribunal rightly allowed the assessee's appeal on the said issue. This court had an occasion to consider a somewhat similar issue in the case of Principal Commission of Income Tax 1 Kolkata versus Shukdam Infrastructure LLP in ITAT number 164 of 2023, dated 14th August 2023.
After the questions, after the questions formulated, short question involved in this appeal, your lordship has recorded, formulated the question. The short question involved in this appeal is whether the assessing officer, which had initially issued notice under 143(2) of the Act for a limited scrutiny of the return filed by the assessee on 3 aspects, could have expanded the scope prior to obtaining approval for a complete scrutiny by the appropriate authority. This is the question, my lord, which your lordship.
In the said case, an identical contention as raised before us was raised, stating that at best the action of the assessing officer could be construed to be an irregularity. While considering such a contention in Sukudam Infrastructure LLP, the court rejected the same with the following observations. Page 6, paragraph starting, while considering. In the light of the above, no grounds have been made out to interfere with the order passed by the tribunal. Accordingly, the appeal fails and dismissed. Substantial questions of law answered against the
Item number 4.
My lord, in this matter.
No, I'm with the appellant.
Mr.
Well, in this
Duria is
application-
appearing, my lord, he has requested me to pray for Passover.
Passover is not possible today. What was the writ petition for?
Well, it is a violation of principle of natural justice. We, in response to the 148 AB notice, we have filed a reply on 7th of April 2023. That 7th of April notice, my reply has not been considered. Second, my lord has already decided in case of Giridharilal Dalmia that the 148 notice has to be issued faceless. It cannot be issued by the jurisdiction assessing officer. These 2 points are involved, my lord. The learned single judge has decided on the basis of that approval. Approval has not been taken. That point also be taken, madam. As officer of the court, this point cannot be arise because of the reason there is an amendment made in 1/4/2023 that 148 proviso, 149.
We'll take it up next week.
Next number.
Who's appearing?
Mr. Duduria.
At the request of learned advocate for the respondent, next week or delay. We have heard so and so, 53 days delay condoned. At the request so and so.
Great, man.
Next week.
Item number 5.
I am for the respondent. Before my learned friend starts his case, I would like to have your lordship's kind look at because this is coming from the tribunal. So before the tribunal, there was an order of commission. Now my lord, they kindly come to page 72. This is the order of the commissioner. My lord, the running page numbers are at the top. It is telling, but at the bottom, my lord, will find 1 page each. The even number are missing.
My lord, to that extent, I submitted that order is also in page 130.
130.
130.
Okay.
Same order.
Same order. Volume 2.
Now, what was the issue before?
My lord, issue before your lordship, the DGRM has found throughout the India, some of the exporters are taking IGST, but their existence are not found or fictitious. And my lord, to that extent, my lord, some of the customs broker has connivance with them. And in this particular case, it is found that the custom broker has transacted the business of 10 exporters. And from where 10.79 crores of IGST has been gone. So, my lord, thereafter the department has come to know whether their existence is correct or not, and whether the customs broker has taken proper care under section 10, under regulation 10N of the SID. My lord, it has been found that according to regulation 10N, whether they have properly done the work or not. But adjudicating authority held that there is no such work has been done by the customs broker. But tribunal held that no such requirement is required provided under regulation 10N. My lord, your lordship will kindly see the order of the adjudicating authority that starts from my lord. And second thing, my lord, I will like to submit before one thing before. Your lordship.
What is 10N? You read 10N?
Yes, my lord. Your lordship will 10N.
Is it quoted in the tribunal order?
Yes. It has been recorded. My lord, that is
174.
174.
Verify correctness of importer exporter code number, goods and services tax identification number, identity of his client and functioning of his client at the declared address by using reliable, independent, authentic documents, data or information.
So whether they have intimated any such step by using reliable, independent, authentic documents, data or information. They have supplied KYC. That does not mean I have fulfilled my obligation. Anybody can supply anything. Can it be reliable? That's why you have been given this instruction. You have to obtain.
But what the tribunal says is, he has verified all those documents.
What documents?
the IEC, GSTN,
Yes.
Aadhaar, PAN, etc.
Yes.
and process the export or
Yes.
import, whatever it is. Later on, if the man is missing from that
My lord,
address,
later on, the man is missing. That is not the question. The question before your lordship was the functioning of his client at the declared address. We are saying that they are not at all in the declared address.
no, on the but page 185 para 20, tribunal says yes, it was verified. Subsequently, they ran away.
No, they are not saying that they verified the documents. They are relying upon the documents which the exporter has supplied. And on that basis, they are doing this. The tribunal is misconstrued the provision. The liability upon the customs broker is to functioning his client at the declared address. Whether they have done so, to that extent, what is there? They are saying we have got the KYC, their PAN card, their GSTN number, their IEC number. But that is not the question.
Page 172, para 13.
Page 170.
Para 13.
Para
13.
Yes. The appellant submissions report the inquiry officer that the adjudicating authority as well as before us is that they had carried out the due diligence as required under regulation 10N by obtaining the documents. Well, that is the question. By obtaining the documents will not suffice.
He need not go to their office and see whether it is open or locked.
Then your lordship will.
You see 10N.
Yes.
Now you read 10N.
Yes, yes, yes.
174.
174. Verify correctness of importer exporter code, goods and service tax in identification number, identity of his client and functioning of his client at the declared address by using reliable, independent, authentic documents, data or information.
So he says 9 documents: rental agreement,
yes,
cancel check, electricity card, electricity bill, PAN card, company PAN card, GST registration.
Who has given? They have the exporter has supplied their producing. Have you gone? Have you checked? Anytime, any point of time, is there any whisper? And the fictitious companies are there, they are extracting the money from the government, 10.79 crores. How would they have verified? Suppose, my lord, I am in state of Delhi. I am supplied the documents. They are saying, yes, I am taking the documents, then I am clearing the goods. Have you ever checked? Have you ever gone? What is their antecedents? Whether they are fictitious, whether they are doing the business, what is there? And why the custom broker has been appointed here in my lord? You are here to suppose to do the clearance work at the same time, you will be the person who will responsible for the interest of the revenue. And second thing, my lord,
tribunal has
yes,
referred to another judgment in the case of Annex Air Services.
Yes, they are completely relying upon the said judgment.
Page 175. This appears to be a good reasoning. Page 175.
Yes.
The question, third line.
Yes.
Which arises it is that it has the customs broker to satisfy himself that these documents are the copies given by his client, where it indeed issued by the concerned government officers, or does it mean the custom broker has to ensure that the officers have correctly issued the document? In our considered view, the obligation
under regulation 10N
cannot be read to mean that the latter as it would amount to treating the customs broker as one who is responsible to oversee and ensure the correctness of the action of the government officers who issued these documents. It will also mean the regulation under the Customs Act will prevail over the actions under the Foreign Trade Act, under so and so.
Yes.
Therefore, then skip 2 lines. Therefore, the verification of certificates on the part of the obligation of 10N is fully satisfied as long as it satisfies itself the IEC and GSTN were issued, indeed issued by concerned officers. This can be done through online verification, comparing with original documents, etc. Does not require an investigation into documents by the customs broker. Presumption certificate of registration so and so is being correctly issued. 79 of the Evidence Act requires to prove the certificate is purported so.
My lord, copies are here. My lord, these judgments copies, my lord. Page 12.
No, they have quoted the entire judgment, my lord. Entire judgment they have quoted.
No, but see, suppose in
Yes.
your case is that the Aadhaar card or GSTN was a fake document.
I am saying, my lord, they are not existing in their place. They are not doing their business. It
But
is
then
that.
there are 10 authorities which have given certificate. This man is a very nice man. He is doing business in this place.
Yes. My lord, who has given?
Government has issued.
I have given the IEC number. I have given the GSTN number. I have given the other documents. My lord, whether it is not their duty, my lord, that duty had been cast upon them under regulation 10N to verify the antecedents of the said exporter. Your lordship will kindly appreciate. And again, my lord, I will submit before your lordship, my lord, the tribunal has held that they are required to verify.
No, he can't put him under surveillance. No, put CCTV camera
No.
and see whether the client
That is
there.
not in the statute. That is whatever in the statute, my lord, that has to be. Your lordship will kindly see the decision of the tribunal of.
You register a criminal case against.
My lord, your lordship will kindly appreciate this. But how the customs broker will act in this fashion? They will act in this fashion.
You are filing a matter, not e-filing, physical filing. You are affixing the required court fee by way of labels or by way of stamp paper.
Yes.
The department accepts it. What it sees is there. The label is. Can you ask this filing department to take it to the forensic laboratory and see whether what Mr. Maiti has given, whether it is a fake stamp paper or a fake label?
But
so he presumes that it is.
My lord, but if
then you unearth.
Then, my lord, then
we trace the problem. Then we register a case, investigate.
My lord, then in that event, your lordship will, if the statute does not permit me, then your lordship can be easily taken action against me. I am saying the statute says so. You cannot violate the statute. Only to that extent, your lordship.
Have the missionary, sir.
My lord, your lordship will kindly see the tribunal's order.
What you can do is,
yes,
you add an amendment to the statute saying that on perusal of these documents, the broker has to do a verification, cross verification, by making adequate request in the portal. The portal will generate a reply. That reply should be enclosed or kept on file. Something like that, you give some suggestion. This is unworkable, sir.
My lord,
you fill up the gap. You fill up the gap.
My lord, my 10A is specific, my lord. My lord, to that extent, my lord, I will say, my lord, they are functioning of his client at the declared address.
No, admittedly, these 10 exporters who were facilitated by the respondent were later found to be non-existent. But according to him, on the date when he effected the exports, he had these documents. There is a presumption to the validity of the document. Not existing in that place is something different. False document or a fake document is something. Your case is not, it's not a fake document. He is non-existing in that place.
Yes. Well, that documents have been obtained by fraudulent activities.
What?
Because, my lord, why I am submitting, the person who is doing the business, can he vanished? Today I have obtained 10.7 crores, 10.7 crores, and tomorrow I am not here.
You register an FIR against him, you'll get him.
Against whom? Against this customs broker and all.
Exporter.
Against the exporter, and custom broker will go free hand. Who has connived with this matter?
Right. But
Who is not
coming from the bar.
My lord.
All right. Have you filed an appeal against this Annex Air Services?
No, Annex Acts, my lord, I don't find, my lord. Now, the second thing, my lord, I have submitted before your lordship. Kindly see the second judgment of the tribunal.
My lord, this is annex judgment. My lord, to answer the query of your lordship, my lord, subsequent to annex, another judgment has been passed.
Arjit, we have not asked any query. We are arguing your case.
No, well, definitely. But the annex here, my lord asks that whether they have preferred any appeal or not. That is, my lord, what I am submitting.
No appeal.
No appeal. In fact, after that, another order passed in the same line. My lord, annex this case, and this case, my lord, will find S. Prakash Kuswara. Here, my lord, kindly come.
That is also tribunal, my lord.
My lord, kindly. I have some patience, Mr.
Yes. That is also
my lord,
tribunal.
My lord will kindly come to
Principal bench, New Delhi.
Yes, kindly see one thing that kindly come to page para 8 of page 3. My lord, some A, B, C, D, my lord will find.
B is annex.
B is annex, C, D. So total 5 cases, my lord, same facts arising out of the same DG-ARM report. In my case also same DG-ARM report. Now, my lord, in this particular case, what my learned friend has forgotten to point out, but the inquiry report is annexed in the stay petition is in my favor. Holding the same thing what annexed in annex case and other 5 cases hold by the tribunal.
Where is the inquiry report?
Yes, my lord, kindly see the inquiry report
Yes,
is at volume 1. It starts from page 28. The relevant part, my lord, will find
34. No.
34 is the finding and discussion. Prior to that, my lord, page 33 is important.
Yes.
What documents for these 10 exporters I have submitted have been scrutinized by the inquiry officer one by one.
Yes.
Now thereafter, no, everything is used. Mr. Bajaj, have some patience, please.
Yes.
I'm requesting. Now, my lord, thereafter, kindly come to page 35. Paragraph 11, he referred to regulation 10N. Then paragraph 12, my documents he has referred. And thereafter, at paragraph 13, he has come to the conclusion at page 36 that there is no violation. Now, my lord, now the tribunal, now the commissioner has disagreed with this. He has the right to disagree, he has disagreed. Though in a manner he has disagreed was not acceptable. Anyway, there was no disagreement. I'm not going into that. Then tribunal order, my lord, kindly see. My lord was looking into paragraph 13 at page 172. My lord will kindly see paragraph 14 and 15.
No, let us see how the commissioner disagreed.
Yes.
How? My lord, by way of giving a PH note sheet, by saying the assistant commissioner is saying, commissioner has disagreed, you come and join PH. Tribunal has noted that also.
Kindly come to page 130. That is the order of the adjudicating.
That is the order.
Yes.
There was no disagreement note prior to that.
Yes.
I'm not reading those things because those are not required in this case.
My lord, that has been, everything has been discussed in this case by the adjudicating.
And my lord will see paragraph 14 and 15. My lord, my learned friend was saying that I am required to verify whatever. You are saying antecedent is not under 10N. Anyway, my lord, here the commissioner, the inquiry officer, as well as tribunal has recorded the fact that whatever documents I have obtained as KYC and I have verified, it is not only IEC GSTIN, it is also having a blank check and a certificate from a nationalized bank attestating the signature of the exporter. Thereafter, in all these cases, exports took place. The functioning of the exporters at that relevant point of time cannot be questioned because the export took place. The case of DG-ARM is that those were overvalued exports. So the export is not in dispute.
So under the Customs Act, there is no show cause.
No show cause. DG-ARM report saying that IGST refund was taken by these exporters excess, and today on physical verification,
The factum of export is not in dispute.
not in dispute. DG-ARM case is that these risky exporters, they have made, my lord, throughout India, 3007 risky exporters list they have made. And they sent to each commissionerate by saying, see who are the customs brokers and verify the offense report. What they are saying, the offense report simply says, kindly check whether this custom broker had verified the KYC, because today these exporters are not existing.
Offense report is drawn by the jurisdictional commissioner.
Not.
If offense report is drawn, normally it will be preceded by a show cause under 124.
Yes. Here it is not the case.
So if he has not done so, the export is not in dispute. Probably quantum, value, that may be in dispute.
Against whom we will take? They are non-existing.
No, that is for DG-ARM and IGST
That is
authority.
non-existing.
That
Against
is
whom
not
we
your
will take
concern.
the action.
That is not your concern. Your concern, you are under the CBLR. Your
Yes,
concern, yes.
I am under the CBLR.
Kindly see page 24, paragraph 2. Page 24, paragraph 2, first sentence. The entire fact will be clear, madam. The tribunal has come to the specific finding that at the relevant point of time, exports have taken place. If the exporters were not there, who exported? And it is his case that exporters took IGST refund. But if exporters were not there, then who took the refund?
That is the connivance.
Ah.
That's why the connivance. The person who is
it is
not,
coming.
then how you have done this?
But you should catch the main man.
Correct.
He is the main culprit.
Well, if a person does not exist, whom I will catch?
It is not for him, it is
if-
for the IGST
For
authority.
your lordship, if I am not, then with me, who is arguing before your lordship?
What happened was
Yes,
that 2005 exporters,
yes.
Yes.
when the exports took place, what they have done, nobody knows.
Only on this
DGRM
email, they are
report, my
acting.
lord,
Only on this email. Kindly see, first sentence and email from DGRM.
then your lordship will kindly come to the second page.
And that is why this all
My lord,
bunch
kindly
of
come to the
orders are
second page,
coming from
paragraph
tribunal.
4. On scrutiny of the list provided by the DGRM CB,
Hmm.
Sun Glory Agency filed 204 shipping bills
Yes.
of 11 exporters without verifying the KYC of exporters, and total GST of rupees 10.79 crores has been refunded to the exporters. Details are here in such and such.
Then
My lord,
I say that I have taken the
That figure is not your concern.
yes.
I am not concerned about that. I am
10.78 is not your concern.
Yes. Now the question before your lordship, whether they have confirmed their duties in accordance with regulation.
That
10.
we will decide. That we will decide.
Now your lordship will kindly come to the adjudicating authorities order. And what is the tribunal's independent finding?
Yes.
Tribunal is completely relying upon that decision.
Not at all.
Tribunal has relied on that decision
Yes.
with regard to the scope of inquiry or verification which the broker has to do under 10A.
Yes,
For that, they have borrowed that principle.
my lord.
And that appears to be the consistent stand of all the tribunals.
My lord, kindly
And
see.
that is why you have not preferred appeal.
Yes. And my lord, the independent finding of tribunal in this case is at paragraph 14, 15. And thereafter, my lord will find, after referring to the judgment of the other case by the tribunal, the independent findings are categorically given at paragraph 17, as well as at paragraph 20. 14, 15, 17 and 20 are the independent finding of the tribunal with respect to the present case.
My lord,
It
your
is
lordship
not
will-
that they have only referred to the earlier case.
It is virtually impossible, sir. It's
My lord, your lordship will, I'll just point out one thing.
Assuming we accept your case.
My lord, I just point out whether the learned tribunal is exceed his jurisdiction by non-relying the report of the IGST authority. How the tribunal has denied the said documents, whether the tribunal has that power.
Not at all.
Because the IGST, because the CGST Act is not given the power to take decision by the tribunal. Because this tribunal is under the Customs Act. How they have
This tribunal is under both.
no, please. How the tribunal has gone into the merits of the documents which are supplied by the GST authority, how he can interfere therein?
Tribunal has not gone into.
Your lordship will kindly see the order of the tribunal. I will just point it out before your lordship. Your lordship will kindly come to the question which has been formulated by the tribunal. My lord, kindly see both the paragraph 170, page 171. Heard both the appellants and the departmental representative, we observe that in a narrow compass, the question which need to be answered. Given the factual matrix of the case and the evidences available on record, whether the learned principal commissioner was correct in holding that the appellant custom broker has violated regulation 10N of the CBLR 2018. If the answer to A above is affirmative, kindly mark the word affirmative, can the revocation of license of the appellant to custom broker be sustained? Is it affirmative? If it is affirmative, then yes, they are formulating the question in a negative way.
That is one way of formulating.
But the construction of the word, kindly see.
No, what they say.
Then your lordship will kindly.
If the answer to question A is yes, then what they have to see whether this can lead to permanent revocation.
Yes.
Or in other words, with regard to quantum of penalty or quantum of punishment, whether it should be suspension for 3 years, suspension for 5 years, or permanent revocation. Then if similarly, if the answer to question A is yes, whether full forfeiture of security deposit should be ordered.
Yes.
Then if it is yes for A, whether 50,000 rupees penalty should have been imposed.
My lord, your lordship will kindly come to page 180, paragraph 34. They have quoted the order. My lord, your lordship will
You
kindly
are
see.
flogging a dead horse.
My lord,
Getting 50,000 rupees from that fellow, and he will be out of business.
my lord, that, my lord, I am not to that extent, whether the person will be out of, I am before your lordship, whether my substantial question is there or not, and
100% convinced.
my lord, just last submission before your lordship will kindly come to page 180, paragraph 34. They are relying upon the decision of the annex here, my lord. Kindly see, that has been quoted. Paragraph 34. On a query from the bench as to how the customs broker can be fouled when he relied on the IEC, GST registration and several documents issued by the government, and if the exporter did not exist at all at the premises, how these documents were issued by several government officers. Learned departmental representatives submitted that officers issues those documents as per their mandate, which does not include physical verification of the business premises. He further clarified that in almost all these cases, the registration are issued by the officers based on one-line applications. They are not mandated to ensure that the exporter exists and are functioning from the premises, but the custom broker is so mandated by regulation 10B of the CBLR 2018, which obligation does not get obliterated or diluted by the fact that the officers of various departments have issued these documents. To that extent, what is the findings of the tribunal? Where the rebuttal of the tribunal that we are not accepting this submission. We are not accepting the submission of the learned advocate. And what is the reason?
Tribunal says that he has collected all these documents and refers to the earlier decision to hold that he is not required to do physical verification of the business premises of the exporter. Now, the exporter is not traceable. The whatever is the refund has already been availed, gone. And now this is actually not an offense report. If you read page 24.
Yes, my lord.
Second paragraph, last 4 lines. After analyzing the data for 2710 adversely reported cases of identified risky exporters, including 2005 exporters who could not be verified physically, untraceable, it was revealed 62 custom brokers had handled consignments for multiple untraceable exporters. Therefore, he says he should have verified the functioning of his client.
Yes.
That is it is not an offense report at all.
No, offense report is saying that this has been the risky exporters. And in this
should
case,
have drawn an offense report after a show cause is issued under the Customs Act, in which you can make him as a co-noticee.
that permission can be given to your lordship.
No, not now. Which fellow is all?
My lord, your lordship, now at the initial stage, your lordship has directed that observation was that you take the criminal action. Kindly did that. We'll take the criminal action against.
That was against the exporters, my lord.
My lord, why not the customs broker? He is free hand. He has to given the free hand. You go and do this all these illegal activities in connive with the exporters who are not existing.
Therefore, if according to you there is material to show that the customs broker also benefited out of the refund, then applying the theory that a person in possession of stolen property is also a thief, you proceed against. That's not your case.
That is kindly see. Then I will see, my lord. Then your lordship will kindly see the adjudicating authorities order. Yes, my lord. How he has.
Adjudicating authority obviously will confirm because it is coming from somebody, the report, he won't differ.
No. It is found that he is a monetary benefit. He has done this for monetary benefit. That has been the objection. Maybe the person who is not existing, then who has taken the IGST? The person who is not existing, then who has obtained? Your lordship will kindly come to page 150. That is the
So
discussion.
therefore, you intimated to that department, UDIA, whatever that department, you intimated to IGST office, you intimated to GST office, they'll commence their investigation. Please come.
That observation, your lordship, I pray that observation from your lordship.
All
My
right.
lord. But the person who are in this matter, in such type of matter, they will ruin the entire backbone of the country. This is the whole system, my lord. This is going on. The person who are not existing, you are exporting the goods and taking the IGST.
Non-existent exported. And taken the refund also.
This appeal has been filed by.
My lord, last submission, my lord. That is the decision of the tribunal. Another decision of the tribunal, my lord. That is the Delhi tribunal. Delhi tribunal. HLPL. My lord, only one paragraph. Paragraph 8. HLPL.
Case of 124.
Paragraph 8 only, I will read. Regarding the following KYC norms by the appellant, we find that the statement of Sri Vivek Sharma dated Sachin, the employee of HLPL, has stated that when he went to collect the documents, Sri Uday Bhagat asked him to come in a street at Fatehpur, wherein he was standing before a building which did not have any signboard or BR number. It is seen from the adjudication order that the declared residential premises of Sri Uday Bhagat and Sri Sundar Prakash Sharma, the directors of Messrs Notex Extreme Private Limited, they were not residing at the declared premises. The adjudicating authority also found that the IEC of the importer revealed that no form of business enterprises in the name of Notex Extreme Private Limited existed at the given address, and the inquiries conducted and the declared residential premises revealed that the said address was incomplete and fictitious. Under the circumstances, we are in agreement with the finding of the learned adjudicating authority that CHA helps not properly verify the functioning of the client from the declared address by using reliable, independent, and authentic documents. This is a serious lapses on the part of the CHA in verifying the KYC before taking up the custom clearance of the consignment of rough diamond imported by Nexon Private Limited. The appellants, considering the nature of the imported goods of rough diamond, would have exercised more vigilant approach before taking up the consignment for customs clearance after verification of the KYC norms of the importer, which has not been done in this case. It is stated by the learned advocate that the order of the adjudicator has failed to discuss the various cases laws such and such. We find that the adjudicating authorities dealt with each and every case and such and such. So, my lord, this is also the tribunal's order.
That was the case where notice under 110 was issued, 110 subsection 2.
And that is 120, but the observation of ratio of the 10A. The observation of 10A is the same.
Paragraph 7 talks about the show cause proceeding under 124.
That may be, but that does not mean the 10A has gone.
Extended the time limit for issuing show cause notice, and
Yes.
ultimately 124 was issued.
Ultimately,
And it was
124.
adjudicated.
Yes.
10 lakh rupee penalty was also imposed.
My lord, here also, my lord, why I am relying upon paragraph 8, my lord, that is the ratio of the 10N.
Lack of vigilance, sir.
10N has been here declared, and how they have paid the tribunal has not. If they had relied upon this decision of the tribunal, why not this is decision? There is a contradictory decision.
We will consider.
My lord,
This appeal has
I'm
been
deeply
filed.
impressed.
Thank you. This appeal has been filed by the revenue, challenging the order dated 31/3/2023, passed by the Customs, Excise and Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata within bracket Tribunal, in order number 75193. The revenue has raised the following substantial questions of law for consideration. Page number 20 of the stay petition.
Page 32.
Para 32. Question 1.
My lord, one additional question I have formulated, if your lordship kindly consider this. One additional question.
1, 2, 3, and this will be 4. We have heard Mr. K.K. Metil and Semi Standing Counsel so and so, and Mr. Arjit Chakraborty and Advocate appeal for the respondent. The respondent is a customs broker who has been issued a license under the provisions of the Customs Broker Licensing Regulations 2018 within bracket CBLR. A show cause notice under Regulation 17 within bracket 1 of the regulations of the 2018 regulations dated 16/10/2020 was issued, calling upon the respondent to show cause as to why the customs broker's license issued to them should not be revoked and their security deposit not ordered to be forfeited under the provisions of Regulation 14 for violation of the provisions of Regulation 10 within bracket small n of the CBLR 2018. Pursuant to the show cause notice, an inquiry was conducted. Pursuant to the show cause notice, the respondent submitted their reply, and the Assistant Commissioner of Customs within bracket Airport and Administration bracket close Custom House Kolkata was appointed as an inquiry officer to inquire into the matter, who had afforded an opportunity to the opportunity of personal hearing to the respondent and has drawn a report dated 18/3/20. What is the date of the report? Page 36, it is not very clear. 18/3. The report dated also 18/3.
2021.
2021.
36.
পড়া যাচ্ছে না, তোমার পেজ 36 পড়া যাচ্ছে না। The Principal Commissioner of Customs within bracket A&A, Kolkata, did not agree with the report on the ground that the report has been drawn ignoring vital evidence, and the report is not legal and therefore not acceptable. And accordingly, a notice was issued directing the respondent to appear for a personal hearing. Pursuant to which, the Principal Commissioner of Customs, instead of that, you can put PCC, sir. You can abbreviate it earlier. Pursuant to which the PCC passed final order, order in original dated 8/8/2022, holding that revoking the license, the customs broker license granted to the respondent, and forfeiting the entire security deposit, and also imposing a penalty of ₹50,000. Challenging the said order, the respondent preferred appeal before the tribunal. The tribunal, by the impugned order, has allowed the appeal. Aggrieved by the same, the revenue has preferred the present appeal, suggesting the aforementioned substantial questions of law. The issue which fell for consideration before the tribunal was with regard to the role of the customs broker, qua Regulation 10 within bracket small n of the 2018 regulations. The said regulation reads as follows. Page 134. And it is extracted, sir. I'll mark with red pencil. Please extract. In terms of the above regulation, there is an obligation on the customs broker to verify the correctness of the importer-exporter code within bracket IEC number, IE bracket close number, comma, goods and services tax identification number
within bracket GSTIN bracket close, comma, identity of his client and functioning of his client at the declared address by using reliable, comma, independent, comma, authentic documents, comma, data or information. Thus the question was whether, thus the question was as to how the customs broker has to undertake the verification process as mandated in regulation 10 within bracket N of the CBLR. As could be seen from the report drawn by the Assistant Commissioner of Customs within bracket, not accepted by the principal PCC, bracket close, comma, the respondent has furnished the list of documents which he had collected from 11 of his clients, and which includes 11 of his clients. And for illustration, we take up one of the clients, namely Vaishnavi Trading and Suppliers. The documents produced by the respondent were GSTIN ID inquiries screenshot from Indian, sorry, sir. It is in page 33, sir. GSTIN, all capitals, space ID, all capital, both capitals, inquiries, apostrophe S, screenshot from Indian Customs EDI system, comma, KYC form, comma, form GST REG -06, comma, copy of PAN card, comma, copy of Aadhaar card, comma, acknowledgement letter dated 15/10/2018 from Karnataka Bank to Deputy Commissioner of Customs, and certificate of IEC with number issued by DGFT. The respondents the respondent's contention was that after collecting all these documents, and verifying the same, comma, and upon being satisfied that the respondent has done the due verification in terms of the obligation cast upon them under 10 within bracket N, process the concerned document, process the documents for 11 of the clients. As could be seen from the records placed before this court, there is no dispute to the fact that the exports have taken place and refunds have been sanctioned and paid to the exporters. The case of the department is that the exporters are not traceable. Admittedly, no case has been and admittedly no action has been initiated under the provisions of the Customs Act against the exporter, nor any show cause notice was issued under section 124 of the Customs Act against the exporters or the respondent customs broker. After having found that the exporters are not traceable, there appears to be a feeble attempt made by the department to pounce upon the customs broker by proposing to examine as to whether the customs broker has done the proper verification in terms of the obligation under regulation 10 within bracket N of the CBLR. The learned tribunal has examined as to how the verification process has to be done by the customs broker, and in this regard had placed reliance on a decision of the coordinate bench of the tribunal in the case of Anax Air Services Private Limited versus Commission of Customs, New Delhi, passed by the principal bench of the tribunal in Customs Appeal number 50987 of 2021. Uh, The learned tribunal noted it will be extremely difficult, if not totally impossible, for the customs broker to physically visit the premises of each of its clients for verification. Full stop. The tribunal also has held that the regulation gives the option of verifying using documents, data or information. And if there are authentic, independent and reliable documents or data or information to show that the client is functioning at the declared address, the obligation on the customs broker is fulfilled. Furthermore, the documents which have been issued by the various authorities of the state of the central government has not been shown to be either fake or forged. Therefore, the tribunal concluded that there was no reason for the customs broker to doubt the authenticity of those documents or doubt the reliability of those documents. It is not the case of the department that the documents which were produced by the respondent customs broker were fake, were false and fabricated documents, and there is nothing on record to even remotely suggest such a allegation. The tribunal has, in our view, rightly held that the customs broker, that the obligation of the customs broker under regulation 10 within bracket N does not include keeping a continuous surveillance of the client to ensure that he continues to operate from that address and has not changed his operations. And after noting the decision in Annex Air Services, the learned tribunal has also considered the facts of the case on hand and where is paragraph 17 of the tribunal's order? Yes, no. Facts of the case and noted that the original offense report was based on DGARM report, as in the case of Annex Air Services. And the tribunal on facts found that the respondent's customs broker has verified all the documents such as IEC, GSTIN, Aadhaar, PAN, etc. Submitted by the exporter before processing their shipping bills. The decision in Annex Air Services Private Limited was noted by the principal bench of the tribunal in the case of S. Prakar Kushava and Company versus Commission of Customs within bracket Airport and General bracket close New Delhi 2023 384 ELT 89 within bracket TRI-DEL. From the said decision, we find that all the cases arise out of a common report drawn by the DGARM. Full stop. And the appeal filed by the appellant therein was allowed. As could be seen from the language employed in regulation 10 within bracket N, comma, it cannot be read into the regulation that there is an obligation on the part of the customs broker to ensure the correctness of the action of the government departments or the documents which have been issued by the various government departments. All that is mandated under the said regulation is verification with the verifiable data and documents. Reliable, independent and authentic documents, data or information. The stand taken by the respondent, even at the time of inquiry, that the set of documents which were produced clearly would satisfy the mandate under regulation 10 within bracket N of the Act. Thus, we are of the view that the learned tribunal has rightly explained the scope and obligation under regulation 10 within bracket N, and the finding would not call for any interference. The learned is standing counsel appearing for the appellant place reliance on the decision of the learned tribunal in HLPL Global Logistics Private Limited versus Commission of Customs, New Delhi, 2019 370 ELT 501 within bracket TRI-Delhi. We find the said decision cannot be applied to the facts of the present case, as in the said decision, action was initiated under the Customs Act and show cause notice was issued under section 124 of the Customs Act. And the tribunal held that the nature of goods which were imported in the said case being rough diamond, the customs broker could have exercised more vigilant approach before taking up the consignment for customs clearance after verification of KYC norms of the importer, which was not done in the said case. Therefore, the decision in HLPL Global Logistics would not render any assistance to the case of the revenue. For the above reasons, the appeal fails and the same is dismissed, and the substantial questions of law are answered against the revenue. Yes.
Lord, may I be permitted to mention one urgent matter? I have mentioned it on Thursday. It is there in the list as item number 66 of today's appellate side list. My Lord,
We'll see what can be done.
urgency is, my Lord, rehearing will start from Monday. And my Lord, there is no jurisdiction on the part of the local complaint committee on the issue of sexual harassment to entertain complaints. Single judge has.
So please give the letter, let us see.
My Lord, kindly visualize there is another larger aspect, my Lord. The in-house proceeding power of the all establishments in the state of West Bengal will go, even the courts. My Lord, internal complaint committee is there. Internal complaint committee will hear. and coordinate bench judgment and other High Court, my lord, division bench judgment, my lord, internal complaint committee will have to hear the issue on sexual harassment, but the local complaint committee, my lord, have no jurisdiction. Even your lordship, my lord, this Mr. Bhattacharya has passed one judgment on this regard, my lord. Bonani Chakraborty, Chattopadhyay, my lord. There, my lord, it has.
You have to release the matter.
My lord, yes, my lord, extreme urgent, my lord, extreme urgent, my lord. From Monday it will start. Well, on a different matter, his lordship has given this view and different high court.
We'll hear. You given the letter. Let us see.
I'll write it. I will.
Appellate side, daily listed matters, item number 1 to 5.
Supposed to be listed today, my lord, along these contempt applications. These matter may come on next date at 6:16.
Yes, sir.
এই আমাকে একটা কাগজ দাও না।
Yes, yes, Mr. Raman.
Yes, wait, please, Your Lordships. But I just, yes, Lord, yeah. I just, in your lordship, you occupy the full screen. I can see clearly that.
Yes.
Lord, I beg to appear, my lord, in two CPANs, namely 831 and 948 of 23. And I beg to represent, my lord, the State Election Commission in both these matters. Lord, the issue, my lord, today, as had been posed in the last hearing, after Krishna Kumar concluded on behalf of the petitioners and your lordship wanted me to address your lordship, was whether under the Calcutta contempt rules, whether a rule needs to be formally issued or not.
Yes.
Because that is a point which was now brought up. So I'm not address your lordships on the requirement, mandatory requirement or otherwise of issuing a rule under the Calcutta High Court contempt of court rules. May I first, my lord, it straight away innate your lordships to the rule itself, my lord. The Calcutta High Court contempt of court rules 1975. It's completely self-contained. Although, my lord, I would be submitting for your lordship's consideration that insofar as matters relating to contempt of court are concerned, your lordship is actually exercising a dual jurisdiction. One is under the Contempt of Courts Act, read with the Calcutta Contempt of Court rules. Other is the plenary constitutional power your lordship has under Article 215. And there are enough and more judgments, my lord, of the Supreme Court as well as the various courts to suggest that once these combined powers are there, the practice or procedure of how your lordships would like to, my lord, modulate the proceedings in contempt are best left to your lordships. There are certain statutory requirements, of course, which cannot be sidestepped, but otherwise, more or less, my lord, a large amplitude is given to your lordships. And my lord, of all the contempt rules, possibly the Calcutta High Court rules possibly gives your lordships the greatest aptitude, as I would be pointing out to your lordships. But if you see the rules, my lord, which came into force, my lord, on 22nd of August 1975, the rules itself talk about, just make it go. Yeah. Your lordships is straight away covered. There are various procedural aspects in the contents of the petition, format, etc., which your lordships may ignore, my lord. Your lordships will straight away come to, my lord, 19. So your lordships even start with 17. Rules framed by any court on its own motion shall be dealt with by that particular court, etc. Notwithstanding anything, Chief Justice may assign a rule for hearing before another judge or bench if so required under special circumstances. That is 18. And 19 is what your lordship is primarily concerned with. The court may issue rule nisi or summarily reject the petition or make such orders thereupon as thought fit. So, the rule contemplates three possible scenarios which your lordships can adopt. One is, your lordships may issue rule.
Yes.
Secondly, your lordship may summarily reject the petition. Thirdly, make such other orders thereupon as thought fit. The subject I would like to make for your lordship's kind consideration is your lordships have consciously, over a period, I'm going to show your lordships the various dates on which the CPAN has come up for hearing and the orders which your lordship have passed. Your lordship have consciously adopted the third process. And this third process is something, my lord, which I find is available in the Calcutta rules. Madras High Court rules, for example, with which your lordship, the Chief Justice is aware, has only two. You issue rule or you dismiss. But what happens, my lord, normally, and this is, my lord, what the principles of cursus curae or, my lord, the practice of the courts will evolve, my lord, how they deal with contempt jurisdiction. And, my lord, the learned Advocate General with whom I had a discussion last evening, my lord, he is going to address your lordships also on the practice of the Calcutta High Court in matters relating to contempt. But overall, what happens even across India, my lord, in contempt matters, what would happen is, I'm just giving your lordships an easy example to follow, blood to keep as a benchmark. Your lordships give a direction to the municipal corporation. There's an encroached illegal building on Salt Lake. You are directed in a petition filed by PIL or even by a neighbor. Your lordship issues direction, please demolish the building on or before 31/3/2023. Report compliance, post on 15th of April. When your lordship lists the matter on 15th of April, the writ petitioner, successful writ petitioner, files a contempt before your lordship saying we are now 15 days past the deadline. Here is a photograph, the building is still there. Prima facie, they are in contempt. At that point of time, your lordships could straight away issue rule if you feel like it. But more often than not, your lordships will want to know what has exactly happened. Let me first find out before I issue rule. So your lordships will direct the government pleader's office to take notice and report on why it has happened. Let us assume he comes back and says the land building owner has filed a SLP in the Supreme Court. It is coming up on 17th or 18th of April. Therefore, we thought we will stay our hands. At that point of time, your lordships can again do two things. There is no stay. You ought to have acted. You are in contempt. I am issuing you a prior rule. Or your lordships will say, since you are saying 17th of April, this SLP is coming, you will post this matter on 20th, we will see. SLP is dismissed. Your lordships will then ask him, how long are you going now to take? Then he says, I am going to complete the demolition in 3 weeks' time. Then your lordships will give that 3 weeks' time normally and find out. If he still does not do it, he is fully guilty of contempt. Then it's only a question of punishment. So what happens is, the prima facie case, even if it was made out at the threshold, it was not mandatory that your lordships immediately issue rule. Now, in this case, kindly note what has happened, my lord, and that's very important. Your lordships orders, my lord, of 9th June, 12th June, 13th of June are forming the subject matter of the contempt, basically.
Yes.
It has also got confirmed by the Supreme Court by its order of 20th of June. So that's on 21st of June, the CPANs have been moved before your lordships. And on that day, your lordships have passed a speaking order saying the allegations made appear to be very severe. And if they are made out, a case for contempt is also made out. So we are going to now direct the Election Commission to respond to everything which has been stated then. The lordship listed it 2 days later on 23/6. 23/6/2023 is a very important order. Your lordships has recorded everything there on that day which has happened. And my lord, on 23/6, your lordship has actually held that some kind of a prima facie contempt has actually been made out in these allegations. But these are only allegations. I need to hear what the Election Commission has to say. Your lordships will get it at para 13 of your lordship's order dated 23/6. The lordships have said, after we heard the submissions on behalf of the learned advocates appearing for the parties, sorry, would your lordships have the order sheet? It's 23/6/2023. In CPAN 831.
Yes, 23/6.
Yes, brother. Para 13. After we have heard the submissions on behalf of the learned advocates appearing for the parties, we are of the view that in order to decide as to whether there has been any willful non-compliance of the directions issued by this court in its order dated 15/6, which in fact was ancillary and supplementary to the earlier order dated 13/6, we are of the view that affidavits needs to be filed by the State Election Commission. The crucial question would be as to whether the submission made on behalf of the Election Commission that there is no willful delay on the part of the Commission, as they have complied with the orders on 22/6, soon after the SLP filed by them was dismissed by the Supreme Court. The question would be as to how the delay was to be. Your Lordship formulated also, should you have waited for the SLP or not? But that stage went. That stage went off. Thereafter, your Lordships have finally said in paragraph para 18, we expect the Election Commission to answer the prayer on merits without raising any technical objections, as we have observed that the orders passed from time to time are incidental and ancillary to each other, and the object behind passing such orders is to ensure free and fair elections and to preserve the purity of the election. We direct the State Election Commission to file their affidavit covering all the aspects by 27/6/2023. Then your Lordships listed the matter again on 28/6/2023. On 28/6/2023, your Lordship passed another order. There were certain allegations made about some persons, polling officers, etc., non-deployment of contractual staff. Your Lordships directed the Election Commission to verify the same, and if there's been any violations, to take care of it immediately. Thereafter, at para 16, your Lordship say, we direct the matter to be listed on 3rd July and a report to be filed by the Commission. On 3rd July, my lord, the matter is listed. The Commission also files a report. And your Lordship passes a further order on 3rd July. Your Lordship's read blood, para number 11, referred to the report by the Learned Standing Council appearing for the Election Commission, submitted that the details have been masked and there's a foolproof system in place. However, present allegation is that the names and details of the counting officers have been disclosed. If that be so, Commission should take to mask it. That was done. And thereafter, my lord, as your Lordship knows, the next date of hearing was 6th of July. 6th of July, again, your Lordships have passed a very detailed order. It was just 2 days before the polling date, as your Lordship should note. 8/7 was the polling date. All this was orders passed in contempt proceedings as a part of even the monitoring of the election process to ensure free and fair elections take place. Since para 16, your Lordships. Therefore, this court has considered the said aspect and examined as to what directions have to be issued. It is not in dispute that there were large-scale post-poll violences soon after the earlier Panchayat elections, as well as the election of the Legislative Assembly. Though it may not be right for the court to predict any such violence soon after the ensuing elections, yet the apprehensions in the minds of the applicant cannot be brushed aside. As observed by this court in its earlier orders, it is the electorate which needs to be protected, and soon after the elections and declarations, if any violence erupts, it is the public who will be affected. Therefore, this court is of the view that the central forces shall continue to remain in the state of West Bengal for a period of 10 days from the date on which the declaration of results are announced. And in this regard, MHA shall issue necessary orders and instructions to the nodal officer, IG, BSF. All other subsidiary issues which are being brought to the notice of the SEC, etc., have been nominated. Same shall be taken seriously note of. All that this election be peaceful, etc. Your Lordship said list the matter on 11th of July. On 11th of July, counting actually took place in the election process. Then, my lord, on 12th of July, the IG filed this report. When the IG filed his report on 12th of July, your Lordship passed another order. This is where your Lordship made that prima facie observation. Paragraph number 2 of the order dated 12th of July 2023. Para 2.
Yes.
On a perusal of the report, your Lordship is referring to the report of the IG BSF. On a perusal of the report, we find that the allegations are very serious, more particularly the allegation against the State Election Commission. In several places in the report, it has been stated that the support and response of the State Election Commission and the state authorities was found wanting on number of occasions. If the allegations set out in the report ultimately turn out to be true, then it would tantamount to a clear case of willful disobedience of the order and directions issued by this court. However, these are all prima facie observations made by this court, as we would have to take a decision after the Election Commission files their responses to the report. There are also allegations against the state government of non-cooperation, etc. Liberty is granted to the concerned authorities in the state government to file their response to the report of the IG. Learned ASG submitted clear instructions were not given to force coordinator with regard to deployment and other facilities which have been extended, as a result of which the troops are made to suffer, etc. Your Lordship has recorded all those things, and will not the screens of the allegations made by the Additional Solicitor General have all been set out. And finally, my Lord, your Lordships have held in the last page just about para 8, last part of the para 7. In the earlier part of this order, we have pointed out that the allegations made in the report submitted by the BFS are very serious and damaging. Therefore, before we take a decision, we expect proper response from the State Election Commission to all the allegations made in the report, as well as the appropriate authority of the state government. Let such response be filed in the form of an affidavit, not later than 24/7/2023. On 24/7/2023, the State Election Commission filed an exhaustive reply, my Lord, along with the response to every one of the allegations contained, not only in the content, but also in the report filed by the Inspector General of the BSF. On that day, our Lordship said that let the contempt be listed for final hearing, and the first hearing started on 26/7/2023. That is the first day I also came before your Lordships.
Yes.
And Mr. Krishna Kumar started. From then, my Lord, your Lordships will note the petitioners have argued on 26/7, 31/8, 5/9, 16/9, 18/9, and finally on 29/9, they concluded. And when they concluded on 29/9, for the first time, Mr. Guru Krishna Kumar makes a point saying, you have not issued rule. Please issue rule now. The question I asked myself are twofold, my Lord. Firstly, whether it was necessary to issue rule at this stage. Secondly, other than, my Lord, making the election commissioner and any representative of the state government appear before your Lordships, the rule will serve no other purpose, because otherwise the rule contemplated by the contempt of court rules and the act only asks your Lordships to ask them to come and be present and ask them to show cause why proceedings for contempt should not be taken. So please file a detailed response to the petition for contempt and answer all the allegations. That has already happened here. My say to the BSF's report as well as my say to the petitioner's contempt are already on your Lordship's record. All that is now required in this matter is for me and the learned Advocate General to complete our arguments on the merits, covering those 10-12 hours of argument of Mr. Guru Krishna Kumar and his colleagues. And if that is done, at that point of time, your Lordship gets into the position of deciding whether there is contempt committed or not committed. If contempt is committed, then the stage of punishment will come. On the quantum of punishment, what is the remedial action, etc., etc. But what Mr. Guru Krishna Kumar argued was issuing of that Rule 19 rule under Rule 19 is mandatory. It is not true. The wordings of that rule itself gives your Lordships all the three options. According to me, this 15 orders which your Lordships have passed make me believe that your Lordships have consciously adopted the third option. One is to issue rule, other is to dismiss it summarily, third is to pass such further orders as is required. So I personally believe, my lord, and I would respectfully submit it for your lordship's kind consideration, that the procedure adopted thus far in this contempt is perfectly in order. Does not require any modification at all. In fact, my lord, most of the judgments, my lord, on whether rule should be issued or not, deal invariably with two aspects. One aspect will be whether by issuing the rule a prima facie case is contemplated by the court, would that become an appealable order under section 90? Courts have held it would not. Then they have said some cases when the prima facie opinion is expressed clearly, then you can also appeal against it under section 19. The second aspect on which, my lord, the rule issuance became at one point, my lord, critical was from the point of view of section 20 of the Contempt of Courts Act relating to limitation. You cannot maintain a contempt proceeding 1 year beyond the date of the alleged disobedience. So what happens, in one of the matters before the Supreme Court, their lordships analyzed the situation and said, look, issuing rule may become necessary because the commencement of contempt proceedings starts only from the issuance of rule. So if rule is not issued within 1 year, then the contempt, because the contempt is pending adjudication for a long time, the contempt may become infructuous and it would have to be dismissed. That was by a 2-judge bench, which was overruled by 3 judges thereafter, holding that the moment the contempt petition is filed on the record of the court, that itself amounts to commencement of the petition. In this case, the contempt petition has come to be filed on 21/6/2023, on which day your lordships has asked us to take notice. And the contempt, according to them, was a continuing contempt, because the contempt was not on 21/6 alone. Thereafter, the contempt, according to the allegations in the petition, are continuing up to the date of the poll and up to the date, my lord, of election, results, declaration of results. Which is why their arguments itself finally did not deal with anterior position prior to, my lord, 21/6. Their main concern was after 21/6, when your lordships directed deployment, sensitive zones, identification, etc., as the State Election Commission acted with reasonable expediency and efficiency in ensuring, my lord, that the whatever mandate your lordship wanted them to do had been done by them or not. So the entire allegations of the BSF officer also starts from that day, almost from 2021/6, going up to the date of the elections, which is what the Election Commission also defended on a date-wise. In fact, some of them are hour-wise responses of the Election Commission. Your lordships, when I will take your lordships in the merits of the case, when your lordship hears it, your lordships will find we have given responses even on an hourly basis. And we have filed the entire documentation in support of that. The point, my lord, which I will be arguing in the contempt also as a legal issue is that so many disputed questions of fact are going to be involved. Would your lordships want to decide it in a contempt jurisdiction in a my lord, summary manner, or would your lordships delegate it to be decided in the writ petitions where identical issues have been raised? There the relief also will be much more wider if it is turned out to be true. At the end of the day here, if ultimately your lordship feels the State Election Commission has acted with reasonable expediency, may not be with the level of efficiency which we would have thought it could be, assuming that without admitting it. It would still not amount to a contempt of court, because contempt of court, as your lordship knows, is as a twin limb. One is disobedience, other is willful. So for that purpose, to coming to that conclusion would only be, my lord, after your lordships has heard me and the learned Advocate General on behalf of the state on what actions we have taken in response to your lordships' directions vis-a-vis, my lord, the BSF officer. We have, my lord, filed our detailed responses, listing out, in fact, on the very first day of hearing, my lord, I had, for your lordship's easy reference, given your lordships, my lord, a column-wise discussion on what was the allegation in the report and what is our response to it. The entire big affidavit of compliance which we had filed had been circumscribed by me into a much smaller thing, just to show your lordships every one of the points given by them has been addressed to. And at the end of the day, your lordships will also find the report of the BSF officers actually went a little beyond what was even called for. Making allegations that the constitutional machinery in West Bengal has broken down and all that, which are completely way out of focus in what your lordships are deciding. The Election Commission, on the other hand, on its objections to the BSF officers' report, has been, extremely, I would say, decent in the way in which we have answered it, even though we are going to show some shocking facts. We are going to show some shocking facts where almost 100 companies to whom everything had been given even way back in 3rd and 4th of July turned up for duty one day after the elections were over. And in some cases after the results were announced. And they are blaming the State Election Commission for that. But these are the very important issues which your lordships will be addressing before coming to a conclusion that the State Election Commission or the state government and the state government have actually committed a willful default of the orders of this court. Then where is the question of issuing rule today? That's what I'm asking myself. Issuing rule and do what? He will come, he will stand, your lordships will dispense with his appearance once again and say, okay, now file your counter. No, sorry, I've already filed my counter. Then the matter will have to just go on for a hearing. It would have been much more easy if the Advocate General and I had been given this, 2 weeks back, if we had given an opportunity, we would have concluded our hearing during Puja holidays. Your lordship would have reserved judgment in this contempt itself, instead of putting it into this rule nicety argument at all. Now we are into the last week of the court.
No, I think Mr. Guru Krishna Kumar has covered it on facts.
No, he has covered it on facts.
And the last...
We are ready to, therefore, the only thing left is for us to readily reply to whatever he has argued. That's all.
Noted your point. You please proceed in that direction.
But that's what, on that blood, the argument on the factual aspects of Mr. Guru Krishna Kumar, I had mentioned to your lordships, I would like to not be in person and address your lordships in that matter, because they are very important issues of the election. Because on the last order, your lordships have said that you restrict yourself to Rule 9, whether Rule 9 should be issued or not. That's why, even the Advocate General, is actually, before your lordships, I think he should be in court, where he is also going to address your lordships only on the limited question of Rule 19, Rule 19, whether any statutory notice needs to be issued at this juncture or not. In fact,
of course, the subject to correction, the impact of rule is something different. Of course, there are 3 options in the Calcutta rules.
That's right.
And your submission is the procedure thus far adopted was the 3rd option.
Correct.
So the court is yet to issue rule. In fact, their prayer right from the first hearing, after they filed the contempt, was, please issue rule and the commissioner should be there. That is on 21st, when the contempt was filed on
21/6, first day.
21/6. But then things proceeded because even much prior to the election, there are a lot of
100%. Every one of those orders which I referred to, I didn't go through them in detail, but they will all set out your lordship's apprehensions.
Every alternate day, there was some issue or other. So we kept on passing orders after orders here in the writ petition, etc.
Correct. So, and in the contempt also. Even in the contempt, your lordships have passed orders.
Contempt also.
Correct.
Therefore, the argument that no useful purpose would be served.
I'm not saying no useful purpose, but there's one useful purpose served. At the end of the day, whosoever you are not above the law. You will have to come and answer to the court. That answer has got to be done. At what stage is what I'm talking about it. Because in this case,
it may be true that the pleadings are complete. And at this stage, he raises, senior advocate raised a legal issue. Therefore, we have to hear all of you on that. And then...
Correct. Correct, but I'm on your lordship's hands on that. So now if your lordship takes even the judgment which was relied upon by Mr. Guru Krishna Kumar, my lord, which is the Heinz India versus GlaxoSmithKline.
GlaxoSmithKline.
That was the judgment, my lord, of the division bench of Justice Seth and Justice Sinha.
Yes.
It's a 2005 SEC online, Calcutta, page 429. But your lordship's order, my lord, of 5th September will record about the.
We have got.
But your lordship is straight away see. The issue was, what is the nature of the order passed? And whether it is an order which is appealable under section 19. In that context, from paras 6 onwards, your lordship will note, my lord. Nature of the order, whether an order within the meaning of section 19(1. In the context aforesaid, we may now deal with the question posed before us. Before we embark upon deciding the question of law, we may first refer to the nature of the order appealed against. It is the nature of the order which will determine the question. As quoted above, that a single judge was pleased to hold the alleged contemptors guilty of contempt, but before passing the sentence, the matter was adjourned in order to enable the alleged contemptor, being so and so, to delete the so and so, whatever was the direction given for in that marketing, whatever they were doing. In order, ultimately, it was further clarified the order is not complied, then the alleged contemptor run the risk of being sentenced, and ultimately the matter was directed to appear for orders on 17th. This order was passed in the background. There is an interim order, but your lordship will forget about the contents of the interim order. We are not concerned with the merits of the case. Para 6.2. The order that has been passed is an order holding the appellants guilty of contempt. However, no punishment has been imposed. The alleged contemptors have been given an opportunity to purge and report compliance. Upon such compliance, the court would be pleased to proceed to pass appropriate orders, and in default, the alleged contemptor would run the risk of sentence. The matter was adjourned. Thus, this order is not in the nature of a punishment. The order has definitely been passed in the exercise of contempt jurisdiction. When section 19(1 provides appeal only against any order or decision passed in the exercise of jurisdiction to punish for contempt, appeal has to be confined only to such order that implies an order in the nature of punishment. The assumption of contempt jurisdiction has different stages. This is the paragraph which was relied upon by Mr. Guru Krishna Kumar. It is a matter between the court and the contemptor. At the first stage, a rule is issued to give an opportunity to show cause. This relates to the initiation of the proceedings by assuming contempt jurisdiction when brought to its notice upon a prima facie satisfaction. That is not in the exercise to punish for contempt. Inasmuch as the punishment follows finding guilty of contempt. At this stage, the court does not proceed on the assumption that the alleged contemptor is guilty of contempt. Court is not supposed to proceed to punish at that stage, since the court cannot prejudge the issue or presume guilt at the outset. After the alleged contemptor appears and submits their affidavit, the court proceeds to find out whether there is any contempt. Not my case was, this is the stage we are in today. My learned friend wants your lordship to go to the para 6.3 stage. After the alleged contemptor appears and submits their affidavit, the court proceeds to find out whether there is any contempt. It is in fact a stage of determination of guilt, or in other words, a state of investigation and finding. This is also not a stage when the court proceeds to punish for contempt, but to ascertain whether there is a contempt. If at this stage, the alleged contemptor is found not guilty of contempt, the order will not be appealable under section 19(1). There is no two opinion about the proposition. But if the court finds the contemptor guilty of contempt and gives an opportunity to purge the contempt and adjourn the matter for passing appropriate orders, then can this order acquire a status different from an order finding of no guilt? Answer would be simple and in the negative, in as much as it is the second stage of the proceedings. So they are making it clear. The order at the end of the second stage cannot assume different characteristics on the ground of finding of guilt or no guilt. Only after such finding, the court enters the third stage. The third and final stage, after finding of guilt, starts when the court decides to punish. Now, when your lordship reads this judgment in conjunction with Rule 19, whatever procedure your lordship has adopted thus far would be perfectly in order. Because 19 itself does not mandate the issuance of a rule as a precondition to proceeding with the contempt. But ultimately, we are arguing on a legal semantics. Your lordship issue notice, the commissioner will come stand before your lordships. Their lordships will then ask him to show cause, and then you'll have to thereafter then the statutory notice, 3 weeks notice, he will come and appear, etc. It will only I'm not saying it's useless formality. It is definitely an important step in the proceeding. But what I'm saying is that particular strip has already, yes, that has crossed. That has crossed. We are towards the fag end of the case itself. Main case. And if your lordship will not hears the Advocate General and me, my lord, on 2 or 3 days, my lord, back to back, we'll conclude it, your lordships. At that point of time, your lordships will have concluded stage 2. If your lordships finds on our submission that no willful default was there, willful disobedience was there, the contempt stands closed. If your lordship comes to the conclusion, no, despite this explanation, I think there has been a willful default, stage 3 will then come in. At stage 3, your lordships will call upon the contemptor. You have to purge yourself or I'll have to punish you. Or if there's no possibility of purging, only punishment.
Yes. Now we hear the Advocate General.
Yes, Lord. Please. Yes. There are not some other judgments of the division bench of the Calcutta High Court itself which have dealt with it. There are 2 or 3 other judgments. One of them, Lord, actually is the judgment of a learned single judge, which has actually analyzed, Lord, that situation little more elaborately than even SmithKline Beecham judgment.
Let us see that judgment.
Yes, Lord, please. That's called Bomkesh. It's called Bomkesh Chandrajana versus State of West Bengal. Sonal will give you a lot of copy. This one. Of course, Pillar, as I mentioned, it's a learned single judge.
Okay. Yes.
Whereas 6 onwards, if your lordship takes, 6 and 7 are the relevant portions. The learned counsel,
yes,
the petitioners contended before this court that they have been compelled to proceed with the second contempt in view of the latest judgment in Om Prakash Jaiswal. Well, Om Prakash Jaiswal is the judgment where I told your lordships about the Supreme Court deciding that when the contempt is deemed to have been initiated, in interfering in the question of limitation under section 20 of the Act. The lordships will read out the rest of it. These proceedings dealing with these are: 1, a private party may file or present an application or petition for initiating proceedings for civil contempt. Court may receive a motion or reference from the Advocate General or his consent in writing. That is in cases of criminal contempt. C2, the court may in routine issue notice to a person sought to be proceeded, or the court may issue notice to the respondent calling upon him to show cause why the proceedings for contempt not be initiated. 3, the court may issue the notice to the person sought to be proceeded against, calling upon him to show cause why he should not be punished. In cases contemplated by 1 and 2, it cannot be said that any proceedings for contempt have been initiated. Filing of an application or a petition for initiating contempt on a mere filing or a reference by the court does not amount to initiation. But this part of it would no longer be good law because, as I mentioned to your lordships, a larger bench of the Supreme Court. In Pallav State's judgment, Supreme Court has said just the filing will do to prevent it. But your lordships will now come to on the para 7 on how it will proceed. They set out para 20, then para 7. Therefore, cardinal principle of the above section is to initiate the proceeding for contempt, not to adjudicate the proceedings. But if I interpret the Supreme Court judgment correctly, it will come out that even if such application is taken out by a litigant within the prescribed period of 1 year from the date of alleged contempt, and the time has expired by efflux of time during the pendency of such litigation in the court without issuance of rule, it will lose its force. The Supreme Court has proceeded on the basis of heading of Section 20 of the contempt, which speaks limitations for action. Such heading, if read with the body of the section, one can clearly understand that the same is meant clearly, not ambiguously, for initiating the proceeding, but not adjudicating. The next sentence, Your Lordship, is therefore, how the court will deal with the matter of contempt is entirely for the court to do so when proceeding is initiated within 1 year from the alleged contempt. Some courts are normally issuing rule on the basis of prima facie observations. So am I. But some courts are admitting or issuing notices or issuing show cause notices before coming to an appropriate conclusion. It is depending upon such court in what way it will proceed. However, the real purpose is to evaluate the situation of contempt and pass such appropriate orders by applying its mind as early as possible. But that expediency issue no longer became relevant after Pallav said, because Om Prakash was overruled and they said, no, the filing of the petition itself will save limitation thereafter. So even if the contempt had to go on for 4 or 5 months and it is alleged of an allegation which took place 6 months back, earlier in Om Prakash's case, the contempt would have to be dropped, because by the time Your Lordship's issues rule, more than 1 year from the date of the alleged act of contempt has elapsed. That will no longer be applicable now. No longer, that is not something which should be, Your Lordship's hands are no longer tied on that. On 21/6, Your Lordship has taken notice of the contempt. On that day, it is deemed to have been initiated. No, Your Lordship will not consider, also the judgment, of the Samantha Fe. Yes. One more bench judgment, of the Supreme Court of the Your Lordship's Calcutta High Court in Samantha Fe versus Chalu Chaudhary, which is a 2009 division bench judgment, of Chief Justice Nijjar and Justice Somadar. But there are no, unfortunately, in this SEC online, they don't have any paragraph numbers to this judgment. But Your Lordship should take, there are page numbers given on the top next to the SEC. Page numbers are given. Your Lordship straight away come to page 10, where in the second paragraph, the division bench is referring to the principles of law laid down, in a judgment, Charles Ostenson versus Johnston.
Yes.
In that, Your Lordship will forget about that extracted portion of that judgment immediately after the quotation is over in the middle of that page. In the present case.
Yes.
In the present case, in our opinion, the learned single judge has declined to grant exemption, but it was a case where exemption was sought for from personal appearance when a statutory notice was issued. The single judge has declined to grant exemption without considering the numerous facts pleaded and placed before the learned single judge. Application seems to have been dismissed only on the ground that the same can be only considered upon personal appearance of the appellants. We are unable to agree with the said viewpoint. Then over the page, after extracting the Lordship paragraph 15, they have extracted what kinds of interim orders are passed. And then para 16, they say, what is a judgment? Again, this is all in the context of whether it is appealable or not. Then just the third, just in the 3/4 of the way, bottom of the page 11, in the present case, directing the appellant to travel to India would certainly amount to imposing a monetary punishment upon the appellant, amount of damage that may be caused, etc. Court cannot shut its eyes and ears to the stark reality and insist upon obedience to the exact model form of rule as specified under Rule 19, being the Calcutta High Court rules. In our opinion, the application for expansion is made bona fide in very compelling circumstance. Employees are not Indian citizens in spite of being foreign nationals. Respondents are submitted in the affidavit filed by the respondent. There is not even a trace of defiance either to the authority or etc. Unique circumstances, a compelling case is made out. Then over the page, their lordship say, while considering applications for exemption, court would be justified in not attaching much importance to the social, political, or economic status, especially in cases where behavior and utterances of an alleged contempt are designed. to erode the confidence of the people. It may be necessary to pass suitable orders, demonstrate the principle that no person is above the law. This is all an issue of whether, what will happen if the statute notice is issued? Should he appear? If he does not appear and seeks for dispensing with, what will happen? So it's an evolving thing. The procedure which your lordship will follow is an evolving one. As the nature of the proceeding, it goes on. Your lordships will suddenly find one day the contemners stand before your lordships is contumacious beyond a point. Your lordships will then take a stand saying that, look, too much, I am issuing statutory notice.
Yes.
Yes.
And also is that incidental power. There's one more judgment, my lord, of Sanjay Dalmia, where their lordships say that the power to secure appearance, etc., should be deemed to be a power incidental to punish or to take appropriate steps. That's, I'm just mentioning that to your lordships, my lord. That is the last paragraph, number 44 and 45. Their lordships deal with whether that notice being issued, is it incidental to the contempt or incidental to the punishing for contempt? They say the issuance of the power to secure the personal appearance or presence should be deemed to be a power incidental and necessary to effect the special jurisdiction of the court, namely to punish or to take appropriate steps against the person. So that's a step your lordships can take at any stage, even later. But it is not necessarily in the middle. It would have been something your lordships would have taken at the threshold, or your lordships will take it at the end if your lordship decides that there has been willful disobedience.
In this judgment, last page.
Yes, my lord. In the Dalmia, the very para 44 and 45, my lord. Last but one page, my lord. You about 3 pages before. It's page number 29 and 30. Para 44
and 44.
And in para 44, they reiterate the rule again, my lord. The last 4 sentences in para 44. When an application for contempt is filed, the High Court will have the due and summary power either to punish or reject the same or adopt its own procedure, including power to punish or to direct appearance. It should be noted such power as indicated has not been challenged. Therefore, there's the latitude given, my lord, which is what I prefaced at the beginning itself. Rule 20 of the Calcutta High Court rules seems to give the maximum latitude to your lordships, much more than some of the contempt proceeding rules of other courts. It was reiterates Rule 19, saying that you can evolve your own procedure and pass tribal orders.
Yes. Yes, Advocate General.
My lord, I start, my lord, straight away by agreeing with your lordships, my lord, that a rule is slightly different. My lord, and I, my lord, say so, my lord, for the simple reason, my lord, if your lordships, my lord, look at, my lord, Form 1 first, my lord.
Appendix 1, Form 1.
Yes, my lord, this is, my lord, very important. Upon reading a petition of and their affidavit of verification thereof and our exhibits, and upon hearing, it is ordered that rule to issue calling upon the respondents to show cause why they should not be committed to prison or otherwise penalized or dealt with for having, and my lord, then the contumacious conduct. So my lord, punishment is indicated, and my lord, appearance, my lord is my lord, and my lord, if there is, my lord, an order. And then, my lord, kindly see, rule is made returnable. On the returnable date, it is ordered that respondent shall appear personally before this court. So, my lord, it is, my lord, earlier it was interpreted as initiation of contempt, my lord, under section 20, my lord, of the Contempt of Courts Act. Now, of course, filing itself is initiation. But, my lord, it is really, my lord, the court having applied its mind, my lord, to the case, my lord, says very well, I am now going to actually finally adjudicate whether there is contempt or not, which is, my lord,
in case of civil, my lord, orders or undertakings, my lord, willful or deliberate violation on. And then, my lord, exercise the jurisdiction, my lord, to punish. So, my lord, my lord, would join my lord's issue with my lord Mr. Raman slightly on this, my lord, that my lord, whether my lord a rule is different or not, my lord, and whether your lordships are, my lord, finally proceeding. My lord, I look at it slightly differently. My lord, your lordships, my lord, have seen the orders. I will only rely on two of them. Now, my lord, there are two contempt petitions, my lord, before your lordships, which was being argued, my lord, by my lord Mr. Krishna Kumar, my lord. Now, my lord, the important thing is, my lord, there's no suo motu contempt, my lord, which has been initiated. They're on a petition, my lord, which have been laid. Now, my lord, CPAN 831, my lord, the state is not a party. I'm, my lord, just indicating, my lord, some things factually, my lord. And, my lord, in the next matter, my lord, which is, my lord, 948 of 2023,
Yes.
my lord, 948, my lord, of 2023, if your lordships, my lord, take that, my lord, the cost title again, my lord, your lordships will find, my lord, that, my lord,
Cost title.
the, my lord, state, my lord, is not, my lord, arrayed, my lord, as, my lord, a contemno, but, my lord, three persons, my lord, page 14, my lord, should will find.
Page 14. Chief Secretary.
My lord, three persons. I said Chief Secretary, my lord, then my lord, Home and Hill Affairs, and my lord, the Director General and Inspector General of Police. Individually, my lord, they have been made parties. The point I'm making, my lord, is that the state is, my lord, not, my lord, a party. And state can be a party. My lord, in, my lord, content proceedings. My lord, rules, my lord, contemplate that. One minute. My lord, your lordship may
Third
just.
respondent is, who's the third? Second respondent is Chief Secretary.
Chief Secretary. Third respondent, my lord, is, my lord.
Secretary.
Yes, my lord, he is, my lord.
And Director General.
And, my lord, Director General. My lord, Principal Secretary, Department of Home and Hill Affairs. My lord, they've been named, and, my lord, designations given. Now, my lord, your lordships, my lord, will look, my lord, at just Rule 15. My lord, all petitions in connection with a civil contempt grounded on willful disobedience to a judgment, decree, direction, or other process of court. No, I'm sorry, my lord, Rule 14, I'm sorry. Where the respondent is the central government or the state government, the cost title shall mention the person upon whom the notice of the rule is to be served.
That is why they have been.
Yes. No, my lord, state has not been. It should have said state. And then, my lord, mentioned that. My lord, and that becomes clear, my lord. Your lordships will find that, my lord, in, my lord, Rule, my lord, 26. That's after, my lord, a rule is issued. Rule 26. My lord, upon a rule nisi being issued on a petition, petitioner shall within so and so. Then, my lord, where the central government, state government, or a government department is a party respondent, an additional copy will be filed for service upon legal representative of the state or solicitor to the central government. So, my lord, there's provision for that. Now, my lord, may I come to, my lord, Rule 19?
Yes.
Now, my lord, up to, my lord, Rule 15, in fact, my lord, it, my lord, deals with, my lord, a petition. My lord, once, my lord, it is filed. Then, my lord, what is, my lord, really being heard, my lord, then, my lord, is, my lord, whether, my lord, a rule should be issued, my lord, straight away or not. Now, my lord, as I understood, my lord, Mr. Krishna Kumar's arguments was that we don't have to be heard now. My lord, he has, my lord, made, my lord, arguments, my lord, relied on whatever material, my lord, he felt was relevant. Because, my lord, very little of the petition has been placed, because there's nothing, my lord, in, my lord, the petition. And, my lord, large parts of our affidavit, my lord, the state's affidavit, my lord, has not been, my lord, placed. My lord, your lordships noted, my lord, what has been placed from the state's affidavit in the order. My lord, that such certain indifference, my lord, on the part of the state, which he quoted, and that's it. Now, my lord, the important thing is now we come to Rule 19. The court may issue Rule nisi or summarily reject the petition or make such order thereupon as thought fit. Then the Rule nisi shall be drawn up as far as may be in the model form number 1, appendix 1. Now, my lord, for the sake of argument, my lord, I accept that, my lord, for, my lord, a contempt proceeding, my lord, to ultimately result in a punishment, my lord, Rule nisi has to be, my lord, issued. Question is, my lord, before issuance of Rule nisi, and that's what I see, my lord, as, my lord, the answer which I, my lord, really required to give your lordships, my lord, is, my lord, whether, my lord, I should be heard or not. Now, my lord, when your lordships, my lord, exercise, my lord, contempt jurisdiction, and it's been the practice of the court, my lord, for, my lord, several years, my lord, that I have been here, my lord, normally, my lord, in civil matters, I'm not talking about writ jurisdiction, my lord, civil matters which have, my lord, come up. I'm not even talking about criminal, my lord, contempt. My lord, if there is, my lord, a violation of an order, my lord, usually, my lord, when we joined, my lord, a rule was issued. My lord, the contempt now was not even, my lord, it was all moved ex parte. Order was shown, rule issued, then you come and say whatever you have to. My lord, over time, my lord, once it came to be recognized that, my lord, orders passed, my lord, in the constitutional writ jurisdiction, really enforcement, my lord, could be only, my lord, by way of, my lord, contempt proceedings. My lord, there was the practice, my lord, which, my lord, developed, that, my lord, the alleged contemnors were given an opportunity to respond before, my lord, a rule was issued. Now, my lord,
we have made that clear in the last order.
I know, my lord, therefore, my lord, all that I'm saying is, my lord, I'm entitled to be heard. Rule, my lord, cannot, my lord, happen without me being heard.
So that is why we are hearing.
Yes. So, my lord, so now, my lord, on, my lord, the argument that, my lord, we should not be heard at all, and, my lord, that rule should be issued straight away, my lord, with the greatest of respect, my lord, to, my lord, Mr. Krishna Kumar, my lord, no, my lord, we should be heard, my lord, as to, my lord, whether, my lord, a rule should be issued against us or not. Now, my lord, apropos this, my lord, two decisions, my lord, I wish to rely on. My lord, one is, I am deciding in which order, right? Now, my lord, kindly take, my lord, a Bombay High Court decision, my lord, division bench judgment, and, my lord, our rules are very similar. My lord, all along your order.
Which is that order where we recorded that submission?
My lord, I'll tell your lordships, my lord, after the state enters. My lord, the state enters, my lord, your lordships will find, my lord, in, my lord, the order. My lord, the state entered, my lord, this, where I was noting. My lord, kindly take, my lord, the order dated, my lord, 12th of July, my lord, 2013, my lord. My lord, kindly come to page 3, my lord, of that order. 12th July. My lord, your lordships have that, my lord. Para 2, page 3, my lord. My lord, on perusal of the report, we find that allegations are very serious, more particularly the allegations against State Election Commission. In several places in the report, it has been stated that support and response of State Election Commission and state authorities were found wanting on a number of occasions. If the allegations set out in the report, now my lord, kindly note, my lord, petition, my lord, nothing has been shown regarding state. I'll place the petition. My lord, if the allegations set out in the report ultimately turn out to be true, then it would be tantamount to a clear case of willful disobedience of the order and direction issued by the court. However, these are all prima facie observations made by the court as we would take a decision after the State Election Commission files their response to the report. There are also allegations against the state government of non-cooperation, etc. Liberty is also granted to the concerned authorities, to the state government, to file their response to the report filed by the Inspector General, BSF. Then, my lord, your lordships, my lord, as to, my lord, them continuing, my lord, I had made a suggestion to court, my lord, how, my lord, my lord, Chief Secretary, my lord, could coordinate, my lord, and my lord, fortunately, my lord, there was peace. My lord, kindly come to page 5, my lord, bottom. My lord, where your lordships, my lord, prescribe the procedure. Then, my lord, next page, page 6, in the earlier part of this order, we have pointed out that the allegations made in the report submitted by so-and-so are very serious and damaging. Therefore, before we take a decision, we expect proper response from State Election Commission to all the allegations made in the report, as well as the appropriate authority of the state government. So, your lordships, my lord, felt it proper, my lord, and my lord, this inherent jurisdiction, my lord, in us, my lord, even when deciding, my lord, contempt, that, my lord, before your lordships, my lord, issue a rule, my lord, your lordships, my lord, can give an opportunity of hearing. So, my lord, I only join issue, my lord, with Mr. Krishna Kumar, my lord, in his submission that don't hear them now. I have placed what I had to place. Prima facie, it established that a rule has to, a case is made out and a rule has to be issued. My lord, when the state, my lord, comes into the picture, my lord, and my lord, even if we assume, my lord, that through these individuals, the three individuals, the state.
In our order dated 29th September, we have done this.
Yes, now, my lord, I am, my lord, first showing how the state comes in. So your lordships wanted. Now, my lord, kindly come to, my lord, your lordships order 1st of 5th September. My lord, before I show 29th, my lord. My lord, paragraph 3, kindly, and this is important. My lord, para 2, my lord, my learned friend, my lord, Mr. Krishna Kumar, my lord, places rule 19. My lord, kindly see, my lord, I want to show you, lord. After elaborately referring to the factual matrix as referred to in the report, the force coordinate and response given by the State Election Commission to the various paragraphs of the report and also certain paragraphs of the exception. And your lordships, my lord, had summarized it in the previous order. My lord, that, my lord, indifference, my lord, on the part of, my lord, the state. That was, my lord, all that was read out. The learned senior advocate referred to Rule 19, it is submitted, contemplates 3 scenarios. The first of which is the court may issue rule nisi or summarily reject the petition or make such order thereupon as thought fit. It is a submission of the learned senior advocate that the orders passed by this court in this contempt application earlier were in the nature of third scenario, or in other words, the third limb of Rule 19, and presently the court has to consider issue rule as per first scenario provided for so-and-so. In this regard, learned. So, my lord, this was, my lord, the argument. Now, my lord, your lordship kindly comes to, my lord, paragraph 8, my lord, of that order. Further, it is submitted that in CPAN so-and-so as well as CPAN so-and-so, various specific instances have been highlighted, and these instances have to be dealt with, for which affidavits are required to be filed by respondents, alleged contemnors. Therefore, it is submitted that once the court finds a prima facie case of violation, Rule nisi has to be issued to explain the concept of Rule 19 of so-and-so. Reliance was placed on the decision and so on. So, my lord, then, my lord, kindly now see your lordship's order, my lord, 29, my lord, which your lordships pointed out. My lord, para 1, it is submitted, my lord, page 3 of, my lord, that order. 29, para 1, third line, your lordship sees. It is submitted by him that at this juncture, the respondents are not required to be heard in the matter, as it is the prima facie satisfaction of the state as to whether rule had to be issued or not. Nevertheless, we have been hearing so and so, and we have also in as to how the matter to be proceeded with. My lord, my lord, bow down to this, my lord, because your lordships invited and because your lordships, my lord, exercise that inherent jurisdiction to hear us, because we must have, my lord, our story before, my lord, issuance of rule. Then, my lord, therefore, the court proposes to hear on the limited issue as regards issuance of rule or otherwise. My lord, so, my lord, whether, my lord, I should not be heard or whether, my lord, I have to be heard. Your lordships, my lord, has made that clear. So, my lord, I can, my lord, straight away, my lord, my lord, get into, my lord, the matter as far as the state is concerned, or if your lordships want, my lord, after Mr. Raman argues, my lord, on merit. Yes, now, my lord,
This
correct.
hearing is only on.
Very well, my lord. Now, my lord, I want to show your lordships, my lord, the two petitions. My lord, kindly take. My lord, kindly take the first petition, 831. And my lord, I can give your lordships, my lord, two cases on this, just for completeness. My lord, before I go, my lord, I'll quickly, my lord, one is, my lord, Bombay High Court, Division Bench. My lord, it's, my lord, 2003, SCC Online, Bombay, 1179. My lord, I'll just trouble your lordships, my lord, with, my lord, paragraph 13, my lord, which is at print page, my lord, 7. Just give a copy. My lord, kindly come to page 8, my lord, of, my lord, that print. My lord, just above the dotted line where page 163 is, if your lordships take 10 lines above that, the rules regarding procedure to be followed for action, either under Article 215 of the Constitution or under the provisions of the Contempt of Courts Act, cannot take away the inherent power of this court, affording opportunity to put forth its say before taking the decision to proceed against such party for contempt, is nothing but an action in conformity with the basic principles of natural justice, and may always be adhered to in cases where the material placed before the court by the complainant, though may disclose prima facie case, they may not be sufficient to constitute sufficient proof to hold the opponent to be guilty. Therefore, whether the court should issue directly notice of contempt proceedings or should opt to issue notice before admission would depend upon the facts of each case. An absence of provision in the rules will not prohibit the court from issuing notice before. And, my lord, the division bench judgment, my lord, which, my lord, Mr. Raman, my lord, cited, my lord, I had got it for a totally different purpose. My lord, to show, my lord, that this can happen. My lord, kindly, my lord, take, my lord, 1989, 1 Calcutta High Court notes, page 48. My lord, kindly see, my lord, paragraph 12.
We'll have the SCC online.
If the paragraphs numbers tally, my lord, then that is, my lord, para 12. My lord, kindly come to para 12. My lord, these were books when, my lord, we used to mark on the book. So, my lord, I have it marked. My lord,
it won't tally.
My lord, para 12. I think it's print page 4.
Sentence starting, however, on.
Yes, my lord. My lord, this was the order, my lord. Kindly see. One of the orders which was challenged. However, on 1st June 1988, I'm sorry, my lord. Print page 4, my lord. However, on 1st June 1988, the concerned CO proceedings appeared in the list before the learned trial judge with the two applications as mentioned herein before, and he, after hearing the parties, was neglected to pass an order, was pleased to pass an order to the following effect. Now, my lord, kindly see. Application for contempt dated 30th May. So, my lord, this is the order being passed in the contempt petition. Because there was a writ also, my lord. The contemnors respondents are directed to show cause why contempt proceedings should not be drawn up against them for violation of the order passed within 4 weeks. Let this matter appear in the list on 29 for orders. Contemnors respondents are directed to be personally present before this court on the date fixed and shall not leave court without permission. In the main writ shall serve copy. So, my lord, why contempt should not be initiated? So, my lord, why rule should not be initiated? And, my lord, they were also directed to be present. So, my lord, the appeal, my lord, said, my lord, there is no rule being issued, but I'm still being asked to be present, which cannot be done. Now, my lord, kindly come to, that's, my lord, only from this order, kindly come to, my lord, paragraph, just one minute, sit. Paragraph 42, my lord. Which page is it?
29.
My lord, page 29, my lord. Kindly take page 29.
Yes, in the facts and circumstances.
Sanjay Dalmia. My lord, in the facts and circumstances, there has been no doubt that no order was ever made or passed and they cannot. We are further of the view that while making the order dated 1st June, the learned trial judge has not decided any list finally. Moreover, he has given duly, kindly note this, the appellant a further opportunity to show cause whether a rule for contempt should or should not be issued. My lord, we are at that stage. My lord, my learned friend, my lord, I don't join issue with my lord Mr. Krishna Kumar. My lord, when he says we are at the 3rd stage, yes, we are at, my lord, we are in fact before, my lord, Rule 19. Because, my lord, after, my lord, hearing us, your lordships might not issue a rule, might just give one direction, or your lordships might dismiss it also. As against, my lord, in fact, my lord, my endeavor before your lordships would be, as far as the state is concerned, my lord, summarily reject, my lord, the contempt. And, my lord, there would be, my lord. Now, my lord, your lordship, and my lord, I don't need to, my lord, para 43 is also, my lord.
This position is clear.
Yes. Now, my lord, kindly take, my lord, the first petition, CPAN 831 of 2023. Take out one. Keep it. When I ask you, you should be able to produce it. Kindly give me one. Move this. Move the others. Now, my lord, kindly see, my lord, who the alleged contemnors are. Page 7.
State is not a party.
No, not at all. So, my lord, I am, my lord, now showing, my lord, why your lordships, my lord, should, my lord, not issue a rule in this at all.
To the state.
Yes. Now, my lord, kindly have a look at in the matter of willful and deliberate violation of solemn judgment and order dated so-and-so, by, my lord, kindly see page 2, by Sri Rajiva Sena State Election Commission in the following. So, my lord, the specific acts of contempt which are required to be mentioned, my lord, in the cause title, my lord, in the body and in the prayer is only concerned with one, my lord, contemnor. My lord, nobody else. And, my lord, then, my lord, comes, my lord, all, my lord, have, and, my lord, your lordships, then, my lord, turn to, my lord, the next, where state, etc. is mentioned, is, my lord, the cause title of the main petition. And then, my lord, kindly come to, my lord, page 6. My lord, contemnor is only Rajiva Sinha. So, my lord, neither, my lord, my lord, and my lord, without fear of contradiction, my lord, in the petition, there is not one single allegation, my lord, against the state in this. And, my lord, I would respectfully submit before your lordships that, my lord, till, my lord, the order, my lord, which your lordships passed, my lord, in July, my lord, 2nd of July, my lord, all the orders, my lord, talk of compliances by the Election Commission. There is not one, my lord, direction, my lord, on, my lord, the state. None at all.
No, there are some small minor directions like convene a meeting, have a joint meeting.
My lord, that came, my lord, after that order. My lord, on my suggestion. Because, my lord, after, my lord, the first order, my lord, of your lordship's right, my lord, the first order, My lord, then, my lord, we had 15th, my lord, where, my lord, your lordships, my lord, provided what was to be done, but my lord,
No, I think that's in the writ petition, not in the contempt petition.
yes,
The writ petition.
correct, my lord,
The elections.
13th, your lordship's right, my lord, sensitive booths. Then, my lord, came, my lord, the 15th order. And the contempt which is complained of is 15th.
No. The directions or whatever observations against the state were made only after the IG's report. Only after.
Correct, my lord, that's it. That's 2nd July, my lord.
So until then.
Nothing.
831 state, there was no allegation against the state.
None. My lord.
Their grievance was that she was not acting.
Yes, and your lordship seen paragraph 18, my lord, of, my lord, the order, my lord, which your lordships, my lord, passed.
Yes.
My lord, paragraph 18 talks about rule in terms of, my lord, 831. So, my lord, I say, my lord, 831, as far as 831 is concerned, my lord, there is, my lord, not, my lord, a single allegation, my lord, against the state, because rule has to be, my lord, in the form, my lord, has prayed for. He's asked for that rule, my lord, in his prayer. And your lordships noted, my lord, his submission, my lord, the day before, my lord, 5th of September. Your lordship sees paragraph 18, my lord, of that order. My lord, the prayer is, see, various have been, and these have to be dealt with, for which, therefore, it is submitted that once rule nisi has to be issued. And the rule nisi prayed for here
is against Rajiv Sinha.
And, my lord, the acts which are, my lord, mentioned there, which, my lord, don't, my lord, cover, my lord, the state at all. Now, my lord, I come to, my lord, the second petition. Kindly have a look at that. My lord, this is, my lord, 948. My lord, my lord, take, my lord, even if it be termed, my lord, a technical plea, my lord, I take it as the first point that, my lord, state is not here. The cause title does not mention, my lord, what, my lord, the state and, my lord, who, my lord, the officer will be. Now, my lord, kindly come to, my lord, the cause title. This is, my lord, assuming, my lord, the technical objection, and I call it technical also, my lord, doesn't stand. My lord, kindly go into the merits here. Now, my lord, the acts of complaint, contempt which have been complained of here start from page 3. My lord, it goes up, my lord, to, my lord, orders, my lord, which have been passed, my lord, on 21st June, 23rd, 28th, 3rd, 6th, and, my lord, in the contempt proceeding itself, the first contempt, where, my lord, there was no direction, my lord, against the state, and, my lord, order dated 15 June, 2023, where again, my lord, there is no, my lord, direction, my lord, against the state. My lord, this is, my lord, what is, my lord, recorded, my lord, here. And, my lord, this is how, my lord, and now, my lord, kindly see what it says here. By not deploying central and not providing adequate security during the elections to so and so, then, my lord, this is, my lord, then 2, my lord, again, my lord, these orders, then, my lord, which says by not ensuring conduct of a violence-free as well as fair and transparent election, and willful violation, so and so has occurred on 8th, which resulted in failing to prevent violence with so and so. Then, my lord, kindly, my lord, note one point, and I'll cite a decision on this. My lord, the 3 persons, my lord, who have been, my lord, named, impleaded as parties, assuming, my lord, they were, my lord, not a single, my lord, averment, my lord, as to how they did it. Not one. My lord, how, my lord, they, my lord, violated these orders. Or, my lord, aided and abetted, my lord, in, my lord, violating these orders. Because, my lord, aiding and abetting, though not taken as a ground, can be a ground, my lord, in contempt. If it's there, my lord, in the body. There's none.
Actually, in the contempt petition is violation of the various directions issued in CPAN 831.
Correct.
As well as.
And one order, 15th of June.
15th of June in the writ petition.
Correct.
So they are trying to get you inside.
Yes, my lord.
through the
But my
directions.
lord, there were no directions in the, my lord, we are, my lord, your lordship's absolutely right.
No,
This is a
their
very,
allegation was, of course, you issued directions, etc. But the basic infrastructure has to flow from the state.
no, I'll show that, my lord. I'll show, my lord, what my lord has been. My lord, if, my lord, the first point, my lord, I say, infrastructure, yes, from the state. My lord, state, my lord, has to be requisition, my lord, to provide that.
That will proceed later.
Yes. So,
So
my lord,
as of now, 831 clean chit, you are not a party.
yes,
In 948, though 3 have been named, state has not been
No.
named. And there is no allegation against any one of the 3
Yes.
named person as to how they aided or abetted
Yes.
or violated.
how they were, my lord, violating. My lord, this is, I'm on the face of it, my lord. I'm just showing your lordship, my lord, on the face of it. Now, my lord, kindly come to para 15, my lord, which was, my lord, placed, my lord, before, my lord, your lordship. Kindly, my lord, that these are the allegations which I've made. My lord, again, my lord, I am, my lord, showing your lordships, my lord, that, my lord, there is, my lord,
Page 50.
page, para 15, page 34, my lord, of the contempt petition.
Yes.
My lord, nothing. No specific allegation. Now, my lord, there might have been, my lord, a slight slip, my lord, before contempt nors comes in the plural, your lordship will find, my lord, the acts of contempt committed by the contempt no. No, target is one, and that's Mr. Raman's client. And my lord, I must, in fact, I should have on the, my lord, before I started my submissions, my lord, made it very clear, my lord, to your lordships, my lord, that, my lord, we feel, my lord, there has been no violation from the part of the state, and, my lord, unconditional apology, my lord, which is, my lord, our duty, my lord, and to mean it, my lord. Now, my lord, the report, my lord, which has now, I won't even show a response now. My lord, I'll just show the report, my lord, which was, my lord, handed up.
No, that will be relevant for this rule 19 purpose.
Yes, my lord, because, my lord, I'm asking for dismissal. My lord, I just want to show, my lord, suppose I had no affidavit.
Yes.
I had no affidavit. Now, my lord, the first thing, my lord, is, this is not, my lord, a suo motu.
No.
Now, my lord, if it is a contempt, the first point I take, my lord, is this entire document is without, my lord, any affidavit in support. Because I filed, your lordships wanted me to deal with it on affidavit.
Correct.
Now, my lord, there is none. Now, I want to show your lordships, my lord, what is the allegation, my lord, against the
Officer has signed.
Maybe. My lord, we are in contempt, my lord. This is on a private petition, which is being in the form of a complaint. I am not saying that your lordships cannot look at it.
No. If my memory serves right, and when we heard the writ petition, all notes which were handed over from the government and the SEC were unsigned.
Yes, my lord.
Unsigned.
Oh.
Yes.
My lord.
I remember distinctly in the writ petition,
my lord,
where the committee,
my lord, kindly, my lord,
were unsigned.
My lord, kindly,
Initial
don't take
response was
My lord.
completely unsigned. My lord, initial response was not even signed.
Yes.
SEC.
No, both
Both
government
from the
office.
state also.
My lord,
From the state
I
also.
came in.
From the state
I came in later, as you lordship.
Yes. No,
My
because
lord, kindly, my lord, kindly, my lord, my lord.
we
Yes,
let you-
yes. Now, my lord, kindly have a look at, my lord.
the report.
Yes, the report.
Report of IG.
My lord, kindly have a look at, my lord, the report, my lord. I want to show your lordships. My lord, 12B first. Kindly have a look at para 12B. My lord, the heading is response receipt from SEC, state police, district administration, etc., or their failure to respond. Now, my lord, subject to correction, my lord, there is nothing from the state. After the heading is there, a state police, but my lord, subject to correction.
Yes.
Now, my lord, kindly come to page 17, which I, my lord, feel, my lord, really should not have been made by the officer. But, my lord, anyway, he's, my lord, made it, my lord. My lord, middle of the page, my lord, kindly see, despite the fact, Lordship, despite the fact that there has been total failure of constitutional machinery in state of country, namely state election, the opponent could not act to any extent beyond provisions. My lord, nothing. No party. This is, my lord, the mantra, my lord, as far as, my lord, our state is concerned. My lord, I have, my lord,
No, this is in this estimation, it is failure.
opinion. My lord, it's now, my lord, kindly, my lord, instances of non-cooperation by the State Election Commission. My lord, that's the heading. Now, my lord, in this, my lord, kindly, my lord, I am showing your lordships, my lord, where they've used also the state under this. Instances were found where state administration has intentionally delayed in providing the vehicles for movement of troops. This is the sentence. And my lord, I have dealt with, my lord, each one in my affidavit, which will be relevant. Because your lordships wanted to hear us on the affidavit. So I want to, my lord, show, my lord, and I just want to show, my lord, what is all this. Now, my lord, kindly, my lord, this goes on up to, my lord, page 19. And your lordships will first make a general point, my lord, note of a general point. No, my lord, particulars at all. No particulars.
Vague.
Absolutely. Now, my lord, kindly come to, my lord, page 21.
Yes.
My lord, para 16. This office subsequently came to know that deployment of CAPFs at the district level was not done even by SPs, and probably it was done at police station level, and SHOs passed the order for deployment of so-and-so. Details of few requisitions which were received by so-and-so. Moreover, no effort was made by concerned district police authorities to brief the CAPFs about the sensitivity of the issues involved. Then, my lord, kindly come to para 18. My lord, kindly see the heading. Instances of non-cooperation from district administration / police faced by CAPF, SAP, if any. Again, my lord.
According to you, the allegation against district administration,
Yes.
not against your chief secretary or home secretary.
No, nothing.
Or
And my lord, it's vague. My lord, what was, and I'll show. My lord, I've given on affidavit. My lord, hour to hour, minute to minute, my lord, what has happened. My lord, because your lordships, my lord, took it seriously. My lord, I said the response has to be serious. It can't be vague. And your lordships, my lord, were kind enough, my lord, to give that direction before ultimately deciding whether a rule should be issued or not. So, my lord, that's why I say, my lord, it's relevant, because now that the affidavit has come on record, my lord, your lordships will dismiss it summarily against the state. My lord, that is, my lord, my endeavor. My lord, I'm not saying, my lord, that your lordships don't have the jurisdiction. Or, my lord, your lordships can punish for contempt without issuing a rule. My lord, I am, my lord, joining issue, my lord, that, my lord, after the petition comes, then your lordships have, my lord, the authority, my lord, to ask for affidavits before ultimately, my lord, deciding where. Once the affidavit has come, my lord, have to be heard, my lord, whether rule should be issued or not. or there should be a dismissal. Now, my lord, kindly see, my lord, delay, my lord, para 19. Delay in making available transport, accommodation and movement order, etc. to CAPFs by district administration leading to delayed or non-deployment of so-and-so. My lord, due to the apathy of State Election Commission, B, and state authorities had to face a lot of discomfort, etc. Then, my lord, again, my lord, para 21. My lord, mainly, my lord, State Election Commission, my lord, there is an appendage.
Other than that, there's
Nothing, my lord. Then, my lord, one other, my lord, page 26. Further, my lord, just before sub-para A, further, despite the severe hostile atmosphere and non-cooperation by State Election Commission and state authority.
Page 32, para 32.
Page 32, para 32.
But that issue was resolved.
Yes.
District authority did not come to accompany the ballot, not
My
to
lord,
accompany the ballot boxes.
correct.
Reluctance in providing POL to vehicles. They were resolved only after intervention of higher authorities. That is probably at Chief
My lord,
Secretary
yes,
level and
yes.
Home Secretary.
My lord, that's what they, my lord, all that I'm saying is it's completely. Now just, I'll give you lordships a flavor, my lord, of, my lord, my affidavit to show, my lord, that, my lord, why it should, my lord, be dismissed, my lord, straight away. My lord, para 13.2a, my lord, is what I wish to deal with first, my lord. And 13.2b, my lord, they deal with, my lord, not providing vehicles for transportation, etc. My lord, kindly take, my lord, my affidavit, paragraph 13.
Of the state government.
My lord, this is, my lord, an affidavit, my lord, of, my lord, Anindo Sengupta. My lord, he is Special Secretary, Home and Hill Affairs.
There will be 2 volumes.
My lord, there are, my lord, 5 volumes. My lord, I have, my lord, as I said, my lord, minute to minute, my lord, what had gone out. Now, my lord, kindly take, my lord, along with this, my lord, I have dealt with, my lord, para 13, my lord, 2A and B. My lord, kindly see, my lord, the 4th line.
Para 13.
Para 13, page 13.
Hmm.
My lord, I'm sorry, I'm on 13s, my lord, but my lord, I state that as per the deployment plan received, local company so-and-so was supposed to be deployed at Kuch Bihar. However, there were certain allegations on the officers and forces of this particular ad hoc battalion, as they are originally based in Dinhata and Sahibganj area, and this is their area of day-to-day operation. Further, an FIR was also lodged against the commanding officer and other personnel of this company for misbehavior and not following government order on the last day of nomination at BDO office, Sahibganj, 18 June. Owing to such reasons, the district administration requested to the State Election Commission as well as IGBSF force coordinator to change this particular company in order to ensure free and fair election. On 30th June 2023, an order was received with a reference number so-and-so, Government of India, so-and-so, so-and-so, wherein it was mentioned that in modification of office letter number so-and-so, in partial cell so-and-so, in connection with so-and-so, ad hoc 405 battalion will now replace 404 battalion and will be deployed in Uttar Dinajpur, and ad hoc 404 will be deployed in Kuch Bihar in place of ad hoc 405 due to admin. So, my lord, our request was accepted by, my lord, the center. As per order on 30th, ad hoc so-and-so departed from, I'm sorry, my lord. My lord, I'm just reading on. As per order on 30th, ad hoc 404 battalion of BSF departed from Uttar Dinajpur at night and reported at Cooch Behar district at 11:30 hours approximately. It is important to mention here that ad hoc 408 battalion never reported to Cooch Behar district. So there is no question of providing vehicles. My lord, 404, 405 were in the picture. My lord, that was organized. Center, my lord, accepted our request. And my lord, this is what, then my lord, the documents which I have annexed with this is at page 647. I can show your lordships that.
No, we have had a flavor of your.
Yes, my lord, this is what I'm saying, my lord. I have given it at every, my lord, page. Every, my lord, my lord, my lord, state has really been in, my lord, added as an appendage, my lord, to any allegation which is there, my lord, as far as the State Election Commission is concerned.
Because they don't see ACC as independent. They
No,
see
that's-
ACC as part of you.
My lord, that's, my lord, in fact, a different issue. In fact, your lordships,
But yeah, in law, they are independent.
yes. And my lord, and as your lordship,
Constitutionally also, constitutionally completely independent. That insulation is required under the constitution.
it has to be. And my lord, that's my lord, my lord, last judgment, my lord, in state of Goa matter, my lord, where my lord, this, my lord, separation, my lord, is, my lord, required. My lord, they are
All right,
independent. It's-
we will consider this issue.
Yes.
All right. We have heard Mr. P.S. Raman, learned senior advocate, appearing for the State Election Commission, and learned advocate general appearing for the state on the issue with regard to the scope of Rule 19 of the Calcutta High Court contempt rules as contempt rules, and on the submissions made by the learned senior advocate appearing for the contempt applicants. Full stop. The learned advocate general submitted that there is no allegation that the state is not a party in CPAN 831 of 2023, and in CPAN number 948 of 2023 there is no allegation against the state, and whatever has been set out in the report of the IG BSF are vague allegations. And not only that, rules should not be issued against the state, but the contempt petition is also liable to be dismissed in limine. The court will consider and pass orders on the effect of on the arguments advanced by the learned senior counsels on Rule 19 of the said rules, and the other aspects will be considered in the subsequent hearings. To this extent, orders are reserved.
And my lord, I had, my lord, just one more case to cite. My lord, it's a one para, my lord. My lord, this is a division bench judgment of our court. My lord, 1991 SCC online Calcutta 114. My lord, kindly, my lord, just look at paragraph 12, my lord. My lord, the rules which provide for, my lord, particulars to be given, my lord, are, my lord, mandatory. My lord, my lord, unless, because that's in fact, the form, my lord, also requires, my lord, this to be mentioned. Kindly see, my lord. Subpara B.
Of para
12. B, my lord, kindly come. Then, my lord, C. Finally, in spite of an opportunity given to the petitioners to amend the petition for contempt and to bring it within the form prescribed, petitioners singularly failed to properly avail. The amendment sought for and allowed did not improve. Cause title was defective. Violation of Rule 4. Contumacious was not set out as prescribed. Payroll. My lord, these are, my lord, against these individuals and nothing. So, my lord, it has to, my lord.
Lord, my lord would give us a chance to respond to Mr. Mukherjee. But only one point my lord may take note of, if my lord may kindly. My lord, yes, my lord, only apropos to what Mr. Mukherjee has said. Lord, the contempt laws in 948, they have not used any affidavit. They have not used any affidavit either to express or state that no rule should be issued.
You heard what I dictated?
Yes, yes. So, my lord, only kindly consider this. I'll consider that aspect.
Your lordship.
Obliged.
I think in 948, our pleading is ready.
Yes, my affidavit is ready.
Yes, 948, our affidavit is ready, my lord.
All right. The learned advocates appearing for the respondents are permitted to file their respective affidavits in CPAN 940. Advocate appearing for the applicant, liberty granted to file a reply, if any, to the said.
As a lot.
Take it.
So only
Grateful to notice.
As a lot.
দাদা এটা রেকর্ডেড এই যেটা